sure all cell phones are on silent.
I don't know. I have to figure out what else.
I ran out of time last week to move a case in Dedham, so at midnight I'm emailing them. I'll be there tomorrow. Go to You ever run like you have no free time? This business, it's crazy. We got our fourth kid on the way in March.
Congratulations.
I just turned 50. Life's crazy. Our oldest is 20, and I got a 7-year-old and a 4-year-old.
Wow.
We got a newborn. Crazy. You do appeals full time?
Yep.
You like that?
Yep.
A little different animal? A little different than
Yeah.
just trying to...
Yeah, it's all it's what I've done throughout, so it's what I know.
It always reminds me, I used to run an HR department. We had a predictive index test. It was almost like Myers-Briggs, but
Yeah.
it's different. It was created by the military. And they couldn't figure out why like bomber pilots wouldn't make good fighter pilots
Yeah.
and good stuff, whatever. And it created a personality thing.
Yeah.
And it was totally different. And I always feel that way with appeals. Like you're almost like in a room by yourself.
Yeah.
You know, rather than like share with the jury.
There's some overlap, but there's very few people who are really good at both.
Right.
It's almost always, there are a couple that's really cool to watch, but it's rare. Or want to do both.
There you go.
I kept track because there was so many. I just last Tuesday was my
Court all rise.
in like 10 weeks. It's like one of those.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see at the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Walsh. To my left, Justice Hershfang. We will be hearing 7 cases today. The rules are, as they always are here, which is 15 minutes per side and no rebuttal. If parties are on one or the other side of the V are splitting their time, you should let us know what the split is in advance of the of standing up to argue. After 4 cases, we will take our traditional mid-morning break and then return for the final 3. And with that, let me call the first case. It is, it's a partially impounded case, so I want to remind the parties to adhere to whatever the scope of the impoundment order is. I take it the name is not impounded, though, right? The name of the defendant? No. All right, so it is number 24605, Commonwealth versus Hall, and we will hear first from Attorney Martin.
Thank you. May it please this court, Scott Martin for Mr. Hall. Good morning, Justices. The issue in this case is in light of the most recent decision from the SJC and Gannett, whether or not the Commonwealth can bear the fruits of evidence from medical records in an OUI case, a simple OUI case from a defendant who expressly did not consent to the blood draw and expressly did not consent in writing to the police that they not obtain his medical records while the officer attempted to gather same at the hospital. The recent decision from the SJC, and I call the court's attention to note number 4 in Gannett, is distinguished in this case because the defendant in Gannett did not allege, and I'm reading from note 4, has not alleged that the blood draw as part of his medical treatment was improper. It seems that the court's opinion in Gannett is talking about medical records that are gained in the ordinary course of medical treatment. This was not the case. And in this case, Mr. Hall adamantly refused to have a blood draw. He said he had a phobia of needles, he refused other treatment, and the police officer investigating the case brought a form to him and asked if he would consent for his medical results to be given to the police, and he expressly denied that consent. That is different than in Gannett, where as much as we may disagree, and I'll speak on this point momentarily, whether or not it's a test or analysis when we convert the plasma number from the hospital to a range that would be on a blood alcohol content. What I would say on that briefly, I live with the decision, whether we agree or not, is that even if we were to say that it's not a test or an analysis, it is giving a range of numbers. And I'd ask the court, I don't believe this was argued in Gannett, where it's giving a range of numbers, not just one singular number. It is not taking a quantifiable measure and simply converting it. I have a good example, I believe, which would be like if we had the Roman numeral, the letter V, and converted it to the number 5. It would be the same thing. We're not changing anything. But if we look at the decision in Gannett and we look at what actually happens when they convert the plasma serum to a blood alcohol content number similar to a breath test, they're dividing 3 numbers, which is simple, I concede that, but what they're doing is they're accounting for a water interference that might occur in the plasma serum sample, which gives a low, medium, and high range, where it's giving 3 separate and distinct numbers, not just converting the number from the hospital records. And it does require expert testimony, and I won't relitigate that part of it. It's not simply converting one quantifiable number to another, and I think that was missed in the Gannett argument, and I'd ask the court to consider that, and it might be something that would be ripe to go up for reconsideration. But I don't wish to spend more time on that. I do understand the decision states that it's not a test or analysis under the definitions. Yes.
You've covered a lot of ground, and I feel like if you don't slow down, you're going to lose me. So I just want to make sure I know some of the ground we've covered. I think one of the arguments you've made already today is that, well, I'm not sure if this is the argument. It sounded like you were starting to argue that your client's blood had not been drawn for treatment purposes, but then you talked about how he objected and resisted and didn't consent. Are you making the argument that the blood draw was not for the purposes of medical treatment?
Well, the blood was taken. The hospital justified that it was for treatment. I don't deny that, and it's a good question. However, whether or not he consented to that was not is an issue that was not argued in Gannett, and that's why it's distinguished here. He expressly denied consent from the hospital.
That's clear
you understand
from the
that?
facts. Yeah,
So that's what makes it different.
All right, so it is the same as what happened in Gannett in the limited sense that the blood draw in this case, like the blood draw in that case, was taken by the hospital for purposes of diagnosing and treating your client.
Against his will, but yes, that is correct. But and maybe I should have touched upon this earlier and not diverted off. But if we look at the consent provisions of Mass General Law, Chapter 90, 24, 1E, and also 1A, it distinguishes clearly when consent is required. And Gannett speaks at great length about legislative intent and plain language of words and what have you. But the plain language was already decided in Zucchino, Capellucci recently, and it talked about the legislature intended for the consent provision to apply to, quote, simple OUIs under provision 1A, but not aggravated OUIs pursuant to 1E. This is a simple OUI. Mr. Hall was not charged with an aggravated OUI, so the consent provision must apply to him. Otherwise, Zucchino and Capellucci and Moreau and Bohegan have no meaning anymore. And that's not what Gannett, I think it's overreaching to say Gannett overturned all of those cases. It didn't.
But it doesn't have to have overturned them in your client's situation. So your client was not arrested, right? He was taken to the hospital. He made certain statements that gave the hospital concern about his mental health and his capacity. In connection with trying to suss out whether he was a danger to himself, as part of the protocol, the hospital drew his blood. He was still not arrested at that point, correct?
He was not, that's correct.
Okay. So when you talk about consent to a blood draw in connection with an OUI arrest, his blood was drawn before he was arrested.
I'm talking about consent with regards to whether or not a BAC can ever come in, whether it's in a post-arrest or prior to arrest, if it's at the investigatory
So then
stage.
that's talking about the next piece, which is the conversion, right? I mean,
Well, not really, if
Okay.
I could, Justice. Where it was an investigation, the officer went to the hospital. The nurses were well aware. He applied for a search warrant, and the Commonwealth, and we both agree that the analysis conducted by the state action does not come in. He was at the hospital actively investigating an OUI. He hands the defendant, and this is what's so different and I believe distinguishable for Mr. Hall versus other defendants, asks him, can I have your medical records? It's clear he's investigating him. It's clear he wants it for a legal purpose, not for medical treatment, and the defendant says no. Then the hospital asks him, we want to take your blood, and he says no. There was never an issue of competence, whether or not he couldn't make decisions about such matters, and I think that's different. The court did not have to make decisions because he was not competent to appreciate that he did not want a BAC level or any other records provided to the police or the court, which is paramount to the decisions in Zucchino and Capellucci and Bohegan and Moreau. He said no. The fact that they took custody of him because he expressed issues that might be self-harm or what have you, and then took it for medical treatment does not change the fact that the legislative intent was to keep BAC numbers, whether it's a test or an analysis later on, which the court has said no, but it was at some point, and it came from his medical records. And Moreau states it does not matter if it's a third party because it eviscerates the consent provision. So the consent provision survives.
If the Commonwealth, if the testing is done under the direction by or under the direction of the police, which it wasn't here, right? The plain language of the statute doesn't cover this situation. I understand why maybe it should. I understand why one might say, how can it have a purpose that allows this? But the plain language of it allows it.
And that was expanded upon in Commonwealth v. Moreau, where it said, for the following reasons, we agree with the defendant and do not read the statute to apply only where both a blood draw and subsequent chemical test or analysis is done by or at the direction of the police. It distinguished that it would frustrate the legislative intent and the statutory purpose if it was only in cases where the police initiated the consent.
Can I
That's
ask
also
you another question, because your
sorry.
time is running short? I'm sure you noticed footnote 1 of the Commonwealth's brief that says this isn't a proper conditional appeal. If we agree with that, what do we do?
Well, the Commonwealth also withdrew any argument pursuant to that and agreed to have it heard, so I would ask that
I
you...
don't know what that means. It's an improper, unless they've conceded that they can't retry your client, it's an improper conditional plea, right?
Well, our argument is that it was...
I'm asking what we're supposed to do faced with, if it is improper, an appeal without any authority for the appeal under 12b-6.
That I'd ask that you decide it regardless, because it's an issue that's likely to occur over and over without resolution, and it would be...
No, I think it would, it may well recur, but in many, many cases, there won't be other evidence sufficient to allow the Commonwealth to go forward, and they'll enter a proper conditional plea.
I would ask that you decide it, and the Commonwealth is not seeking you not to decide. I appreciate the question.
Would we order the plea to be vacated? Is that what we would do? Or we remand for a motion to vacate the plea?
You could remand, but once again, I did not represent Mr. Hall at the lower level, but I believe it was properly preserved.
I appreciate that, but I'm trying to figure out what we're supposed to do.
I appreciate
I'm actually
that.
trying to figure out whether we have jurisdiction or not. And I'm not sure if this is jurisdictional or not. It appears that the authority for conditional plea I know there was Gomez before the rule was, applied, but it appears that it's the rule that says we can hear these appeals.
I believe you can hear this appeal in the...
Okay,
I believe it was
I'm not
properly,
sure,
the issue was
I'm not sure I
preserved.
understand what, I understand capable of repetition. I assume the result you would desire if the choice was, and we let the plea stand, and so there's a conclusion of guilt, versus the plea has to be vacated because it's an improper plea, and we can go back to square one. I assume you would want the second, but I don't want to, I have no idea. I mean, because that might mean a trial, of course.
Right. We would prefer, well, we would prefer, obviously, the court to render a decision. But
Yes, of
if you
course.
find that you cannot do that, then we would still like to pursue the issue, because Mr. Hall, and I believe it was properly preserved, the issue, and it was expressed at the lower level that this is what he intended to do. And all the briefs indicate the same, and the arguments indicate the same as well.
So it's not that your conditional plea or the trial counsel's conditional plea wasn't very specific about this is the motion, this is the legal issue, right? So hats off to the attorney in the Commonwealth for putting it in writing as required, identifying what the issue and what the legal theory. The problem with it is that the case is still viable, right? So in other words, if it was drugs that were suppressed, and there's nothing for the Commonwealth to try, if you're successful, right, on the appellate issue of the propriety of the motion to suppress,
Right.
then that is why it gets here at this stage. And so we've cautioned in other decisions when the rule isn't completely followed. So when there's evidence in a decision where the trial counsel may not have specifically articulated, but everybody agrees, A, this is the motion, right, and B, if this evidence is excluded, the Commonwealth cannot proceed, right? And everybody stipulates to it, and we hear it. This is a little different in that even if this blood draw were to be excluded, that doesn't mean, not successful, just viable. Viable
I
seems to
understand.
be like it could limp along in this. So do you have any cases that would suggest that by the agreement of the parties, when a particular criteria cannot be met, that it's properly before the court?
All I have is what's in the brief, and like I said, I wasn't the attorney at the lower level, but I understand the question.
And the
What I have
attorney
is
did a
contained in the
terrific
brief.
job.
No, and I ask that the court give deference, judicial economy, and it's likely to happen over and over. And even if he were to go to trial, I don't know if the Commonwealth would pursue it. He already served his entire sentence, probation and what have you. I don't know how viable the Commonwealth would look at it at this point where he's already served the entire sentence. So I'd ask that you consider it, given that at least, that they're not likely to bring it forward because they wouldn't go any further if they won at trial than the punishment he's already received. But other than that, I would ask that you consider, I know the cases are in our brief, I don't want to be redundant, and, but specifically, this case is distinguishable from Garnett, and also the provisions in 24(1)E are not applicable here with regard to consent because it's a simple OUI under 24(1)A. And all of the cases and the legislative intent and the statutes are in favor of Mr. Hall not having evidence used against him for a BAC without his consent, unless it was a better argument if it was in the ordinary course of treatment, not him expressly stating, I don't consent to the authorities, the government, and to the hospital. And I would rest with that, unless you have further questions.
I see none. Thank you very much. Excellent argument.
Justice.
We will hear next from Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. I essentially put everything I know about the Rule 12b-6 issue in that footnote. I'm realizing I have not updated my research on that. I assume if there had been a published decision on it, I would know. But I just flagged
The jurisdictional?
I don't know. I mean, I recognize that's a useful question. I would say the fact that the defendant has served his entire quaff and gotten his essentially sentence dismissed makes me nervous about clawing anything back.
But you're
that's a
unwilling
practical-
to stipulate that you won't proceed, that you can't proceed against him. I mean, you have this.
Yeah, I don't think the evidence supports a stipulation of that. I mean, I think that, presumably the prosecutor who, I don't know. Clearly, it didn't occur to anybody at that stage. This issue came to my attention because we had another case on appeal where this court flagged it of its own initiative, and in that case, they were able to resolve it by saying, we didn't write it down like we're supposed to, but it is true. In this case, it does not appear to be true because there is, and I don't know exactly where that leaves us, but I wanted to draw the court's attention to it for whatever that, in the Commonwealth, in this particular case, does not, again, if
So if we agreed with you that this wasn't a proper 12B6 appeal, what do you want us to do?
So my preference, which I recognize does not answer the jurisdictional issue, which I just don't have anything useful
Let's
to
say
say
it's
about.
not jurisdictional. It looks like it might be to me, but
Yeah.
let's say it's not jurisdictional,
If
but you
it-
have an invalid plea.
If it's not, so the Commonwealth's, I think, policy perspective would be this particular case, given the state of law and the issue, given the state of the facts, given the state of the procedure, it would probably be in the interest of justice if available to
Okay,
just
but I'm
resolve
not
it.
asking for a policy
Yeah.
answer. I'm saying if we have an invalid
Yeah. Mm-hmm.
plea, but we have jurisdiction, right? I mean, that
Yeah.
happens lots of times
Yeah.
in other cases where
Yeah.
someone is actually appealing the validity of their plea or whatever, right?
Yeah.
So we have an invalid plea. What ought we to do with it? Do we vacate the plea?
Where the defendant, whose rights would lie in that case, would like things to proceed as they have been. There's no claim that, he wouldn't have pled guilty but for.
Can I just interrupt?
Yeah.
It's not an invalid plea. Let me suggest that. So an invalid plea is whether it's knowingly, voluntarily
Yeah.
made. This is the conditional nature
Yeah.
of the plea that would be rendered invalid, not the plea itself.
Yeah.
So the question is that you're asking us to decide the merits, to sidestep the issue of whether technically the viability of the Commonwealth's ability to go forward on this claim can be overlooked because the parties agree that it's in the interest of judicial economy and justice for us to render a decision. You want us to render a decision on the merits.
Again,
The way I read your footnote.
Yes, it seemed late in the day to ask for anything else in the absence of law on point. Obviously,
Well,
this
it's not
court
a matter, judicial economy points the other way entirely, right? If you lose, there has to be a whole trial now. If there has to be a whole trial, then what are we doing? We're wasting our time. He might be acquitted after a trial. We might never need to hear this, right?
Yes, I think that the primary, as far as I could tell, the primary sort of equity interest, of the harm would be primarily to this court's docket, which we're already here. But, and I'm not, to the extent, again, the court should do what the court, I don't have anything on, but I'm sorry, I lost my train of thought. But essentially, I'm not arguing that in general parties can assent to this. It just seemed like, because I felt bad because we didn't notice until so late. But, I didn't know that I was going to save the court any time by asking for any other remedy. But
I just want to note that I appreciate your forthrightness, and I appreciate the fact that late in the game, that you're still holding to the agreement, but that you're also identifying a potential issue that you have an obligation as an officer of the court. So I think you did it perfectly.
And I am sorry that I can't provide more sort of suggestions to the court about what the law requires here. I just didn't find anything else. The rule is still sort of, the parameters are in some ways still novel in terms of it being a relatively recent rule where the issue has only come up on even unpublished cases a couple times so far. And given
Talk
that.
to us about the tests.
Sorry?
Talk to us about the tests and the
Yes,
conversions.
so, as we argue in our brief, the defendant not under arrest, test not under direction of police officer. For some reason, they ask him to assent to his release of his medical records. He says, no one ever gets his medical records through that release. the hospital.
Wait, I'm sorry. For some reason, he says, no, you can't have his medical
Well, no,
records?
I said I don't know why they were asking
Oh, I
specifically for him
see.
to assent to it.
Okay,
Yeah, no, I know why he
'cause
wouldn't
I
agree
can think
to
of
that.
lots of reasons he
I
doesn't
just
want you to
I just
have
don't
his
know what the.
medical records.
Given that there's an established purpose for getting the medical records,
Yeah.
or established means of getting the medical records, I don't know why they were trying to get them through consent at that time. But in any event, the hospital, I would argue, based on the medical records, properly tested his blood out of various concerns, including that it hit his head. The government followed the established procedure for getting those records. At the time, obviously, they did try to get a search warrant. This was before Moreau. We declined to proceed with that once it became clear that that was not a valid way to get it. And essentially that nothing in the facts of this case don't fall under 24E1 or 24-1F1, if I'm getting those correct. But in any event, that Gannett, which does have the defendant under arrest and actually refusing consent to police, it was possible to get the hospital records and do the conversion. And that similarly in this case, I mean, in this case, he refused consent to the hospital, which I guess that didn't happen in Gannett, but I think medical consent, I mean, I just disagree with my brother. I think the hospital concluded that he was not in a position to refuse care. I mean, they're sort of taking it from the other direction about whether you can consent to not be treated, whereas consent legally requires you to be in much better shape. But in any event, that, it's not under the terms of 9024 don't apply to refusal of consent only to the hospital, and you wouldn't, the hospital is not going to be making its decisions based on that anyway. If they're doing it for medical care, they're going to do it.
If we found that the failure to include in the plain language of the statute this quirky way things have happened, right? No blood draw by the police, no blood draw under the direction of the police, no testing under the direction of the police of the blood drawn, but just letting the person who drew the blood test it and then putting those records in. If we found that that was contrary to, I guess, what I'd call the apparent purpose of this rule, do we have any authority to say, so it doesn't say this, but since this would be a way of just avoiding the entire, that second part, and maybe they didn't think of it, can we do something about that based on purpose, or we can't?
I would argue no. The sort of the parameters of this are all based in between Bohegan, Moreau, et cetera. And the SJC, I think, has said repeatedly in those cases, we're not deriving this from the legislature's public policy intent. We're looking at the statute. We're saying, here's what they said. Here's why they might have really meant it. And so they rejected, I think it's in Moreau where the Commonwealth was arguing that the public policy issue would not be implicated if police don't draw the blood. And they said, well, but we're not deciding it based on whether this would be a good law for the legislature to do based on what we think they think. We're just using that to inform the fact that they wrote what they meant what they wrote. And so they also in Gannett said essentially that that arguments to that effect are for the legislature, and they're reading the statute as the legislature wrote it. So they addressed that a couple times.
I mean, it seems as if from the teachings of the SJC, there are two boxes, right? One is the police investigation and ramifications of not taking a breathalyzer or consenting to the blood, the equivalent. The second is kind of legislating in a criminal investigation what the hospital can or cannot do. So it doesn't matter, your point is, of whether the defendant says to a hospital attendee, there's no way in heck that you're taking my blood, or please take my blood. If a person shows up, if a police officer shows up at a crime scene, potential crime scene, and there's a person who's unconscious, and a hospital, an ambulance comes and draws blood, it's going to be admissible under 79G, not because the person was under an investigation, it's because it was at the direction, not at the direction of a police officer, and because the person's health was the #1 priority for the hospital or the attendant, right? So if they're unconscious and the blood test is going to come in a later criminal prosecution, it seems to me like it doesn't matter whether the person's kicking, fighting, and screaming, the doctors, or they're saying, go ahead and take my blood, or they're unconscious and unable. It's the way that the legislature wrote it and the way the courts have interpreted it, two separate boxes, two different priorities. That one didn't get touched.
I mean, and I would note that, Your Honor, that this is not a constitutional issue. There is some relatively recent Supreme Court case law about implied consent and its parameters that's not implicated here, and I can't recall immediately what it is. But, you know, there are issues in that area of law, but the SJC has made clear that this is just about this particular statute, where the legislature made some particular choices about requiring consent for a police blood draw in OUI cases.
Because of the ramifications with the registry for loss of license.
And for a variety of, you know, again, the legislature.
Right.
Well, they're protecting the privacy of the blood of the defendants more comprehensively in some way than the Constitution does, and they're entitled to do that. Now, the oddness of it is, since there really is the invasion, is the drawing of the blood, yet they say, and you can't test it later even once it's been drawn, unless they consent to the testing. Now, the Constitution, maybe I'm forgetting something, but I don't think it has anything to say about the testing. I think it's just about piercing someone's skin, taking their blood, and it has all this information that one could get from it. But our legislature says, no, the testing too. And this seems like, I mean, it's not, end run is the wrong word for this because I don't think it's covered by the text, but somehow a non-consensual blood draw by a third party, and certainly no consent to the police, testing for which there's no consent, but it's done by the hospital. But no consent to the hospital is given, no consent to anyone, and yet the text suggests it comes in so that it does look like, not necessarily, but it does look like a gap, you know, an erroneously left gap in the protection that the legislature was trying to give. I mean, I can come up with some other, you know, it may be that people were completely freaked out about the governmental testing, but I don't see any real evidence of that elsewhere.
I mean, I don't know if there is anything actually in the law that says that the legislature intended to make it harder to get people's blood when it's drawn for medical purposes per se. I mean,
of course that's what it says. I mean, I don't know what you mean. It doesn't have a statement, but it makes it harder. It makes it impossible. I mean, with a warrant, a judicial warrant to go get the blood, you still can't test it, right? So obviously it's giving further protection. But, you know, and I'm inferring what the purpose is. Obviously, it doesn't have a stated purpose.
I mean, there's a lot of very smart debate about this, and I'm sure it will continue, and the legislature in both directions can amend if they don't like how the SJC read their statute. But if there are no further questions, I'll rest on my brief.
I see none. Thank you very much. Also an excellent argument. The case is submitted. The next matter we will hear is also partially impounded, so I trust that council will adhere to whatever the scope of the impoundment order is. It is number 24-640, Commonwealth versus PERRO, and we will hear first from Attorney Peterson.
May it please the court. Good morning, Your Honors. Jennifer Peterson here today on behalf of Robert PERRO. Your Honors, despite the trial judge's efforts here to follow the SJC's script in Chalou, Mr. PERRO had a coerced verdict here. The fair inference here is that there was one lone standout. After the jurors got the case, they deliberated for a couple of hours, the jury returned, and said, we cannot come to a unanimous decision on any count. So essentially, they're deadlocked. How do we proceed? Please advise. At that juncture, the court made a decision to give the mini Tui. And the court specifically said that, the verdict must represent the considered judgment of each juror. Don't hesitate to re-examine your own views, but do not surrender your honest conviction as to the weight of the effect of the evidence solely because your opinion of your other fellow jurors or for the mere purpose of returning a verdict. The jury returned for an additional hour till the end of the court day. Next morning, they came and deliberated another 2 hours. And then at that juncture, another letter came out saying, we have a juror who would like to speak to the judge. The juror came out, juror number 9, and juror number 9 indicated that before the juror could say anything, the judge says, I don't want to know what the status of your deliberations is. Are you willing to maintain your oath? And the juror said, yes, that's what I have been doing. I'm willing to maintain my oath and conscientiously decide to try these charges according to the evidence. And so the judge said, okay then, go back and deliberate. And
so far, Attorney Peterson, everything you've described about the trip by the juror is according to the appendix in Shalhoub.
yes, yes.
Can I pause you before you continue? I didn't see a standard of review anywhere in your brief. What is the standard under which we review the judge's decisions here?
Abuse of discretion, I would say, Your Honor.
Okay.
Well, if it's coercive, that's a question of law, isn't it?
Yes, I mean, I think it's also a question of we need to look at the facts of this case. And I mean, this is obviously in your discretion, Your Honors. I mean,
Well,
you're
no,
the
but
one that's
we don't get to just decide things the way we think they ought to go. We're a court of review, not a court of first impression. So the reason I ask about the standard of review is obviously that's the frame through which we look at whatever happened in the trial court. So it's actually really, there's a reason that the rule requires that the standard of review be in the briefs. It's so that we understand the parameters of our job here.
I would just suggest this is structural error. I mean, it's a bedrock constitutional guarantee that you're entitled to a jury that will decide your case and come to a decision beyond a reasonable doubt. And all the cases that deal with deadlocked jurors stress that in the case when a judge is confronted with a deadlocked jury, that they have to scrupulously protect the defendant's right to a fair and impartial verdict. And here, despite the judge's best efforts to protect against the possibility of a coerced verdict, I think, unfortunately, he walked a tightrope where juror number 9, I mean, the only real inference that we can get is that juror number 9 was being squeezed by the jury, and then he came out and he was also squeezed by the judge.
Okay, but the judge isn't ever allowed to ask what's going on in the deliberations, right? So we don't know that, and the judge properly didn't ask. And indeed, more than that, properly,
that is
according to Shalhoub, tried to forestall any risk that inadvertently that the juror would tell him what was going on in the deliberations. So you were up to the point where he had said yes, and the judge said, go back and deliberate, but then he says something that indicates hesitancy. I don't remember what it was. And the judge seems to treat that as requiring him to do what Shalhoub says to do if the person says no, to one of the first two questions, right? He then does that whole bit of, is it personal to you or is it about the deliberations? Again, the juror says it's about the deliberations, and he says, please go back and deliberate, right?
Yes.
So would you agree that he's following what Shalhoub says to do?
Yes and no. And the reason I say yes and no is I think he's attempting to follow what Shalhoub says. But I think where it breaks down is this isn't a juror that just said it has to do with the other jurors. It has to do what's happening in the courtroom. Number one, I think it was really clear when the juror said, they'll do better off without me, that he's the lone holdout here for not guilty.
We can't, we don't know that, and we're not allowed to know that.
No,
So-
we can't and we don't, which is why we have to take care and we have to err on the side of protecting a criminal defendant's rights.
Okay, so what should have happened here instead?
Well, I would suggest, Your Honor, that Juror 9 not only said no, but said no over and over and over again. And despite essentially having his own personal return, repeated return, saying no. And there was nothing to suggest that the Juror 9 was trying to evade his responsibilities as a juror or anything. It was just that he was clearly trying to express to the judge that I can't deliberate with these people. And the judge kept saying, you can't tell me where you stand as a jury. I don't want to hear about the status of
That's
deliberations.
true, isn't it?
Yeah, that's absolutely what they have to do. But the juror made it clear to the judge, I can't, it's really hard to answer your questions, Your Honor, because you've told me I can't talk about where we stand.
So if you were the judge, because in part, it's hard, you're trying to argue an abuse of discretion where admittedly the judge followed Shalhoub, right? So if you were the judge faced with what just occurred, what would you have done to ensure that juror numbers 9's kind of was adequately, concerns were adequately addressed and that he wasn't being coerced or forced?
I would have given TUI again. And the reason I would have given
So
TUI,
the error is the judge not giving TUI?
Again,
correct?
yeah. He
Okay,
gave-
but well, not again, because the first one wasn't a full TUI Rodriguez charge. It was
No.
a general, it's called a mini, but it was a general reiteration about the importance of jurors. But it was not a finding that at this point in time that the jurors were deadlocked, et cetera, right?
yes. I
Okay,
mean,
so the error that you claim the judge made was not in giving a TUI Rodriguez instruction when a juror doesn't refuse to deliberate here, correct?
Mm-hmm.
But showed some sort of ambivalence or concern.
Yes, and I would say, I guess the problem here really is when you look at the two different instructions that were given, and especially if you look at it from juror number 9's perspective. The first time they came out, they were deadlocked. The judge specifically told all the jurors that listen to each other, consider one another's opinions, and don't surrender your honestly held beliefs just in order to reach a verdict. That's what the judge told him the first time out of the gate. Second time out of the gate, when the judge talks to the juror alone, he says, you have to go in there. I have to send you back in. I have to send you back in. The judge just said, I have to send you back in, and I'm not permitted. The judge says, I am not permitted to discharge you in these circumstances, so you have to go back and
But
deliberate.
you agree with that? You don't want him discharged, right? He's the sole holdout, you think?
I don't know if there would be
Right.
another artful way of trying to explore further if this.
They didn't say they were deadlocked, right? Usually before you give a 2E instruction, you're hearing for the second time from the jury that they're deadlocked, right?
Well, I disagree that they didn't say they were deadlocked the first time. They said
No,
we
the
cannot come
second
to.
time when you're saying there should have been an instruction, they were not, you're saying we can infer deadlock, but we weren't told they were deadlocked.
No, we weren't told they were deadlocked, but you get the sense that the other jurors sent this guy out because he wasn't agreeing with them that Mr. Perro was guilty.
But
So
you don't know that, and you said you could explore artfully, and reading Shalhoub, it seems to say, don't explore anything. The jury room is a locked box into which no judge should venture, which is pretty consistent with, I don't know, like a whole lot of years' worth of law. So when you talk about artfully exploring, is that a phrase that's meant to disguise somehow asking this juror whether he's the lone holdout?
No, but I do think that the judge should have at least said to him that you're not required to surrender any honestly held convictions.
Okay,
To him alone?
Excuse me?
To him alone?
I think he should have said it to the whole
Okay,
jury.
so can I now do a slightly different take on this. I mean, maybe this is hypothetical and it doesn't matter. That's not what the TUI instruction says. That's the beginning of the TUI instruction. It then, I mean, I don't like the TUI instruction. I think the TUI instruction is coercive because it says, oh, don't give up your beliefs. But listen, if everyone else thinks something, maybe you're being unreasonable. So why don't you think about that for a minute, right? That's what it actually says. It's designed to get a verdict out of a deadlocked jury. I assume if he'd given Tui Rodriguez, you'd be here, and there'd been a conviction, you'd be here saying it was coercive.
Perhaps.
Right?
but
I don't know what it is. I mean, Tui Rodriguez seems more coercive to me than anything the judge said.
You see, I disagree because what the jury as a whole sees is that juror number 9 goes out to complain to the judge alone and gets sent back in, and then the whole jury comes out to get re-instructed. And the difference in the re-instruction is that this time around, they're not told to listen to anybody's strongly held, each other's opinions, or to honor their own, honestly held opinions. All they're told to do is they need to go back and deliberate, and they need to have a unanimous verdict. So
Because the judge can only respond to the question or the request before him or her. So in other words, if juror number 9 had a GI bug, or whose child, they just got a phone call, is in the hospital, that's a personal reason that they cannot sit and be a deliberating juror, right? And that's a one-on-one type of conversation. Once the judge determined that it was not personal, that it had to do with the deliberative process in the jury room.
yes, but I agree that this
So
is
the juror number 9 wants to speak to you, Judge, does not then say, let's bring all the jurors in and say, listen to this side and you listen to this side and give the Tui Rodriguez. It doesn't.
I agree that, in this instance, the judge had to walk a tightrope and did his best walking a tightrope. But at the same time, you've got a juror coming out seemingly saying, I'm being bullied here in this juror room to change what I believe is my honestly held belief. He's not allowed to say that. The judge isn't allowed to ask that. But then he's sent back into the jury room, and the entire jury is told not respect each other's opinions or talk to each other or you're okay to hold your honestly held
The other
convictions.
jurors don't know what juror number 9 said. Could have said, I have a stomach bug and sitting here is really uncomfortable, right? I mean, so the other jurors were protected and insulated. And that process, I guess my other question to you is, there is no objection by trial counsel, right?
There's no objection, but I would suggest that this is really the judge's province. It's really not up to counsel one way or another. And I'd also suggest that it's a legal fiction to think that jurors who have been sitting there and already came back on day 1 saying that they could not reach a unanimous verdict, that they send out juror number 9, 6 hours into the
Well, you say they
deliberations
sent
today as a
him
stomach
out. The
bug.
question says he wants to talk to the judge. It doesn't say we want the judge to talk to him.
No, it doesn't.
Right.
If the judge did his best, how is that an abuse of discretion or a clear error of law?
I think it's a coerced verdict, and I think even there's case law out there that says even the appearance of a coerced verdict. And here, I think we need to err on the side of, can we really walk away from this and say this wasn't a coerced verdict? That juror number 9.
It sounds to me like there's no verdict in this case other than a deadlock that you would say was not coerced.
I think it should have gone to a mistrial.
Well, that's different than asking for a Tui Rodriguez instruction.
I understand that, but I wasn't trial counsel and I didn't have the opportunity.
Well, no one asked for anything, so.
No one asked for anything. However, it is the judge's responsibility to make sure that jurors are not being coerced. And here the judge didn't know. And even by the judge's own words, he said to defense counsel that I do think there was an issue with that juror. The judge realized that there was an issue with that juror.
Your time has expired, although if there are further questions, I want you to be okay. I see none. Thank you very much for an
Thank you, Your
excellent
Honors.
argument. We will hear now from Attorney Crane.
Good morning, and may it please the court. Jesse Crane for the Commonwealth. There was no error in the trial judge refraining from giving an unrequested Tui Rodriguez instruction after the colloquy with Juror 9. The judge followed I'm not going to call it a script because the SJC made it very clear that their appendix was supposed to be flexible, the protocol in Shalou. He made sure that he didn't make any record about what was going on in jury deliberations, and nothing in Shalou rendered Tui Rodriguez mandatory, and the SJC has made it very clear that nothing ever renders Tui Rodriguez mandatory. It's an abuse of discretion standard, and in these circumstances, the trial judge was well warranted in refraining from issuing that instruction. He had given the mini Tui the day before. The jury hadn't come back again and said they were deadlocked. Juror number 9's no, I don't think can be fairly read as an indication of deadlock, or at least it's certainly not an inescapable conclusion. Neither party was asking for Tui, and the juror ultimately did go back to deliberation without further refusal. The trial judge is in the best position to determine the juror's demeanor, how he's responding to the colloquy, and I think in this case, there's no basis to give Tui.
So this is not really a fair question. I'm going to say that right up front. And if you decline to really answer it, I won't blame you. I was interested that the defense had asked to poll the jury after the verdict, and that each juror, including juror number 9, agreed that the verdict represented that juror's view. Is there any case law guidance, thinking, speculations, rank notions as to why or how that specific articulation of agreement by juror number 9 with the verdict might play a role in an analysis of whether the verdict had been coerced? That was a bad question in addition to being unfair, but if you want to answer it, please.
Are you asking about how juror number 9 responded when he was polled, like specifically what he said?
I guess what I'm saying is it would seem to me that juror number 9 was provided with an opportunity to say, you know what, that's not really how I feel, right? He's asked specifically, alone, just you, is this your verdict? And says yes, which is different from what happens in other cases. Does that deserve any weight? Does it get any like special credit?
I would argue yes, because the jury's verdict is what's announced in court. And I think the fact that juror number 9 had an opportunity to publicly state disagreement, I think indicates that at the end of the day, he said yes, he agreed with the verdict, and he found the defendant guilty.
But if it were a coerced verdict, that wouldn't cure, right? I mean, I don't know how. If later it turned out an investigator was hired by the defendant and one of the jurors said to juror 9, you're going to vote to convict or I'm going to beat the daylights out of you and I'll find you, don't you worry. Right? And he's like, okay. Right, we wouldn't let the fact that he also said, yeah, that's my verdict.
I would agree in that case that would not be a very compelling fact.
So that's my problem. There are two separate and distinct kind of legal arguments being made. One is when juror 9 requested the opportunity to speak with the judge, whether that required a Tui Rodriguez instruction. And Tui Rodriguez is about deadlock, okay? Tui Rodriguez is not about coercion.
I would agree with that.
I mean, it could be an element of why one juror, but in essence, if there's coercion, there's not going to be a deadlock, right? It's a separate problem and a separate illness, right? Of once that sacred area of the jury deliberation room, kind of they go into it. So the first issue is, was it error? And then to some degree, the claim that is not made, that is underlying the request for Tui Rodriguez is that by his very statement of wanting to speak with a judge and saying it has something to do with deliberations, that somehow alerted the judge that this juror was being coerced. Because the remedy, I would suggest, for a coerced juror would be to excuse that juror if there was further findings that, as Justice Rubin said, the jurors felt so strongly, right? There would be something that would need to be done then. It wouldn't be to send you back into the room, right? But there's no evidence.
I think that is the fundamental issue with this claim, is there's just nothing to suggest that the juror was being coerced by his fellow jurors, let alone, you know, there was no coercion coming from the trial judge, certainly. So there's no basis in the record to even get to the question of coercion.
Right.
That's
But
my position.
It's coercion by the judge pushing juror 9 back into the room and rendering a verdict, and some sort of coercion allegation without anything that I can see in the record by the other jurors, separate and apart from Tui Rodriguez.
I mean, I think to infer a degree of coercion here requires just piling on so much speculation about what was going on in the jury deliberation room, which we can't do, and about inferring how juror number 9 was reacting to the trial judge's instruction to send him back. I think there's just nothing in the record to really get to the question. And I think the only legal issue for this court to really answer is, I guess, is it coercive to not give TUI in this circumstance? And I think the answer is just definitively no. If there are no further questions, I will happily rest on my brief.
I see none. Thank you very much. Excellent argument. The case is submitted. The next matter we will hear is number 25298. This is Commonwealth versus Smith. And we will hear first from Attorney Marshall.
Good morning, and may it please the court. Charlie Marshall on behalf of the Commonwealth, also joined by Hans Husenai, who is the ADA who litigated the motion to suppress in this matter. So the Commonwealth is requesting that this court reverse the trial court's order allowing that motion to suppress. We're making that request for 2 reasons, based on 2 core errors of law that the motion judge made. First, in finding that in order for that backpack to be searched incident to arrest, that the Commonwealth needed to connect it specifically to one of the individuals who was being arrested on warrants. And secondly, finding that there was no lawful basis to detain the defendant in the circumstances presented. That first holding was erroneous because the scope of a search incident to arrest is primarily limited by geography and not by items in ownership, as the motion judge found.
So what evidence was put in front of the judge at the motion hearing that geographically situated this backpack near the defendant, the person or persons, it turned out, for whom the police had warrants?
So admittedly, Your Honor, the record is sparse in terms of a specific location in the motel room.
I mean, it's worse than sparse, right? It's empty.
So I would disagree that it's empty, Your Honor. So I think based on the evidence we have, both through the testimony and through the documentary evidence, mainly the body camera footage, that there's an inescapable inference.
I looked at the body camera footage. Tell me where the bag was originally, please. Where in the room?
So this specific bag, I understand there's no testimony or...
Specific bag is what we're talking about.
I agree, Your Honor, but I think the evidence that was produced at the motion by the Commonwealth leads to the not just reasonable inference, but inescapable inference that that backpack was in the room.
Well, yeah,
You
it
can
was in the room.
I'm sorry.
I think we can all agree
all
it was
have the
in the
same.
room. So does a police officer going into a room in which there are a number of people, is that officer allowed to look in every vessel and container inside the room incident to the arrest of one person in the room?
So our courts have resisted a blanket rule that would say that they can.
Yeah.
The rule essentially, the limitation on scope of a permissible search incident arrest and a related protective order incident to that lawful search
Protective
incident
sweep, I
arrest.
think you mean.
So he means an order to arrest, to put handcuffs on other people. That's what you're talking about, right?
No, I'm talking about the search, going into the
Go
room and
ahead.
searching in items, essentially the limiting principle, as I said, is geography, and it extends based essentially to the grab area of not just individuals subject to arrest, but potentially to companions as well, and individuals in that area of arrest, so long as there's an objectively reasonable concern that they too could gain access to those items, and that those items, there's a reasonable inference that, or
So you're saying
objectively-
there was reasonable suspicion that these other people were armed and dangerous?
No, and there need not be,
So,
Your Honor.
so part of what you're saying, I agree with. But the problem here starts with the record, right? And so when you agree that the findings of fact, so you're claiming errors of law.
Yes.
And you agree with the judge's findings of fact. Okay, that the backpack was found somewhere in the room. That's not good enough, let me suggest to you, for a reason. What if there was a safe in the room that was locked, and this defendant's backpack was in the locked safe in a closet? Are you going to stand here and tell me that there's a legal theory under which police could break open that safe and search the contents of that backpack?
I am not, Your Honor, and I don't think that they would. I think that
So-
hypothetical
right.
presents a much different scenario than here.
So
We don't know that
don't
it is.
know. The problem is that other than there's a corner of the room where there's a whole bunch of backpacks, and perhaps, yes, this defendant's backpack was there, or perhaps it was in a safe, or perhaps it was somewhere not within a geographic proximity to any one of the many people in that room. You can't get to that next level of analysis to determine whether or not what the police did was lawful. I agree with you. The court has made it clear that we are not going to micromanage police and say, you first have to search and then put cuffs on, right? And there is an issue about protective sweeps. There's also an issue about scope, but this is neither of those issues. The problem, and believe me, I understand it. I was a line prosecutor a long time ago and didn't realize until I made those mistakes about the record, is that if a reviewing court cannot identify, not even with some certainty, or we don't, this is not a jury argument of it had to be in that pile. This is Fourth Amendment principles. Your obligation is to put forward the evidence by the testimony or body cam of where that backpack was, so the judge can then say, it's within the Fourth Amendment or it's outside the scope. So when I review the findings of fact and the judge said, I have no clue where the backpack is, nobody in this room can say where the backpack was specifically. It's not good enough to say, yes, probably in that pile where all the other backpacks were. That makes sense.
So, Your Honor, respectfully, I would argue, and I disagree, and I would argue that the evidence produced, while admittedly not as detailed as it could have been, does still suffice to meet the burden
Tell
of essentially.
me exactly where it does.
Whose grab area was it within?
So, Your Honor, from the documentary evidence, we can tell this is a very small room.
So you can do a general search,
So
incident to a lawful arrest of a hotel room. That's your, if it's small enough. So in an urban area, all hotel rooms, anywhere in the closet, the bathroom, that's all in the grab area? Because that's not what a grab area is it?
So first, Your Honor, I wouldn't classify this as a general search. I would classify it as a protective
You
sweep.
said protective sweep doesn't include a search of bags. Protective sweep is authorized by Bowie. It means going in and doing, because it's suspicionless, doing a quick sweep to see if there's a hidden person who can jump out at you. It's got nothing to do with opening up and unzipping bags and taking things out of them. Now, with reasonable suspicion, sure, right? Like a so-called Terry, what do they do? A pat frisk of the inside of a car, something like that. right? And then you're allowed to, well, the scope we can debate, but then you're allowed to do some searching, right, for protection, but that's where there's reasonable suspicion. So I don't know where this idea that you can protectively sweep a room by opening every bag in it comes from, and I certainly hope, well, you tell me, where is that from?
So I'm pulling that argument from a series of cases all cited in the Commonwealth's brief, De Jesus being one of them, and Lucido being the other primarily. So in De Jesus, it's a very similar situation here, and it's the case that I would argue articulates the ability of a police officer to perform a protective sweep incident to
What's
a
the
lawful warrant
citation?
arrest. So that is 70 Mass App Court 114, and that is a 2007 case.
Can you go back to where in the record you believe that there's sufficient, I know you said it was sparse, appreciate that, but where it was sufficient for this court to say, in essence, the judge's findings of fact were in error, because we can say with certainty, other than it was somewhere in the room, that it was within a geographic vicinity, giving the police the authority to search it. So my example of it's in a closet in a safe, tell me where you can say the bag was not in a closet in a safe, locked and secured.
So, Your Honor, I'm happy to do that, and I think it, just prior to doing so, it is useful to keep in mind what the exact burden that we needed to show is that essentially our burden was to show that the officers had a reasonable belief, based on specific and articulable facts, that the area and the items in that area could contain or harbor danger.
Right,
And it extended to the grab area of not just the warrant arrestees, but everyone in that room.
Agreed.
So with
locked,
that,
right, so tell me where the bag was so I can say, you know what? Yeah, that was within the reach of 15 people in a small room versus that was in a locked container in a safe. Tell me how I can make that factual finding and say, sorry, Judge, you got it wrong, because there is evidence in the record that says that this bag, not this bag, was somewhere near someone who could have potentially harmed the police.
so I think we can make that finding because the difference here is accessibility. In your hypothetical, where there's a locked safe, that is less accessible to everyone in the room. Presumably, maybe not everyone knows the combination. Here, there are upwards of, I believe, the number is 13 people in this room total.
How do we know
There are-
that bag is not in a locked safe and it's not in the pile of bags, other than it most likely is because that's where they threw all their stuff? That's not good enough for the Fourth Amendment analysis.
So, Your Honor, I think obviously there's no testimony, and the lack of testimony is not testimony, at least for our burden's sake, that there are, and I believe this is supported by the documentary evidence, there's no closets, at least that you can see in the room. There's no safes.
No closets,
around there.
at least that you can see in the room from the body camera footage.
Correct, Your Honor.
Huh. Have you been in a hotel room that doesn't have a closet?
I have it. I can't say that I have, Your Honor.
No, I can't say that I have either. I mean, and it's your burden to show there's no closet, right? I mean, it's actually, no, it's your burden to show that it's within the grab area. There are other issues and time grows short, so can I ask you this?
Yes.
Tell me what's wrong with this analysis. They have a warrant to arrest one person, right? Milton. They walk in and they arrest him. But in plain view is Mr. Humphreys. And one of the officers knows that he has a warrant out. So it seems to me, I think this is right, even without a warrant, with probable cause, someone in plain view, they can seize him. Now they've arrested both of them. Why don't they have to leave? What authority do they have to do anything to anybody else in that room? They detain them all, right? They take their IDs from them, they search them. What is the authority for the police to do that?
So I would argue that it's the same authority that allows them to conduct the search they did, which is officer safety being the core concern.
No, officer safety can be addressed easily. They should leave. They're done with their business. They don't get to detain everyone in the room, I don't think.
So the case
If
that
they had reasonable suspicion, maybe.
The case that I would argue stands for the opposite and allows them to do what they did is Commonwealth versus Lucido, which I go into detail about in my brief. That's a situation where it's a car stop, so a little bit different, but the core principles that led to that holding apply here. It's a car stop where the driver is being arrested, I believe, for lack of a license. But there are 3 other occupants who are presumably going to be allowed to take that car. The court found there that essentially, even despite the fact that they had already effectuated the arrest of the driver, put him in the cruiser, in handcuffs, in a seatbelt, he was no issue. These other 3 occupants were standing by with other state troopers who were essentially guarding them, and that there was still a permissible protective sweep of that car in which they went into the glove box. That was allowed and permissible
So I'm
because
sitting
there
at
was
I'm sitting at my Thanksgiving dinner table 2 weeks ago, and there are 17 people around it. The police come in, they have an arrest warrant for one of them on a weapons charge. They don't have any reason to suspect he has a weapon on him right now, but he does have a weapons charge against him, so maybe he does. They come in and they arrest him. That's what the warrant is for. They can detain myself and the other guests until what? Until they ask for IDs without any basis to make sure who's who? Is that how long they can do it? So they can just run now on all my guests. They can run whatever. It's not just a query. It's whatever they have in them, some in-depth criminal tool to find out everything about them. Is that the law?
So I somewhat would differentiate that hypothetical from here again, because I think the situation changes when they see that second individual that they know
They
instantaneously.
come in and sitting right next to the guy who I've invited unwittingly to my Thanksgiving dinner. Sitting right next to him is his accomplice. It's their lucky day. They arrest both of them. Now they can detain everybody because of the number of people who have, I just don't understand. So your presumption is that all the other people around the table also have warrants against them?
No, so I don't think that was the presumption, although I suspect that the officers may have thought, all right, we have 2 people on warrants, that there might be some other wanted individuals in this room. I'm not running from
I'm
that fact,
trying to
but
figure out why the police can detain these people without any suspicion instead of leaving like they're supposed to do now that they've done their lawful search and seizure.
So I would argue that the detention is reasonable because it's tied to the permissibility of the search incident to arrest, where that detention and of those individuals can last as long as the permissible arrest and the permissible search incident to that arrest and the protective sweep, and in furtherance of the goal of the protective sweep and search incident to arrest, which is to ensure their safety, to make sure that there are no other individuals that might
So
pose a
in my
threat to
living
them.
room, in my dining room, all my guests can be cuffed while the police go around the entire room and look to see if there are any bags or anything they feel like opening. Is that right?
I would disagree with that. I think degree there is a little bit different, but I think where
Why is the degree any different? It's a bunch of people. You've detained all of them while you search around the entire room, apparently. I mean, it just seems, I'm almost a little surprised that this is the Commonwealth's position. I don't understand it. You can go into a hotel room where you have a restaurant for one person and detain the other guests in the hotel room? I don't see that. I don't see where there's authority. I understand about the car search thing and the fear of a bullet, but I also have to say they've finished their business there. They've executed the warrant and even got another person under plain view and arrested him. They're under arrest. These people are no danger at all, right?
So, Your Honor, I would argue that the car situation, the same inherent risks posed to officers and the fear.
Do you have one in a house, in a residence? A hotel room can be someone's house, as you know from the Supreme Court decisions, one's residence.
So, yes,
Do you
Your
have
Honor.
a case where residents, everyone has been held in a residence with no individualized suspicion?
Your Honor, I would argue that DeJesus is similar, where there's a warrant for an armed carjacking. They arrest him immediately upon entry. However, there are other individuals in the house, including 2 other women, one of whom has an open assault and battery with a dangerous weapon warrant out for her as well. There's another individual in, I believe, the upstairs room, another individual in the cellar. And this court found that a protective sweep of that apartment was justified, even despite a heavy police presence.
What was the protective sweep? Was it a search of bags?
It was a search of multiple rooms, and I believe they see a firearm in the basement.
Okay, so they're doing a lawful protective sweep looking for a hidden person, and then in plain view they see a gun.
I would say a protective sweep to eliminate any possibility of danger that could pose.
Well, you might say that, but I'm not sure the cases do. All right, your time has expired, though. I don't want to
Thank you, Your Honors.
I see no other questions. Thank you very much. Very good argument. We will hear next from, if I can find the right piece of paper, Attorney Cox.
Good morning, Your Honors. My name is Brendan Cox, and I don't want to belabor the points too much. I think all I really have to say about this particular case, I think, is that the trial judge is entitled to deference with respect to his findings of fact, absent clear error, as the court well knows. And then, with respect to conclusions of law, the reviewing court, of course, has discretion to review the application of the law with respect to the facts found. But without an appropriate foundational set of facts, as I would suggest the court exists here, there's no basis to overturn the trial court's ruling. The court, at the trial court level, made the best factual findings that he could, based on the testimony that was presented and the evidence that was presented to the court. And I would suggest to the court he made appropriate rulings of law. The Commonwealth cannot sustain its burden. And to be very candid, I don't really think there's much more than that.
Do you agree that a protective sweep was permissible when they came into the room to serve this arrest warrant and arrest the person?
I don't disagree. I'll just say I agree. I agree a protective sweep may be warranted, but I agree with
your brother says a protective sweep can include a search for weapons. Do you agree with that?
I would suggest to the court that that is objectively incorrect. I also would suggest to the court that, and to avoid the risk of misattributing the quote, there's a famous quote that says something along the lines of, one who would exchange liberty for some degree of safety deserves neither safety nor liberty. The protective sweep is a search for persons, a brief search for persons, hidden persons, secreted persons who may pose some danger to the police. In this particular factual setting that underlies the case, before the court, this is a relatively closed room, and it's not just one, actually, it's two. And so to Your Honor Walsh's point about the safe, the factual record is totally void of where the backpack at issue was found, whether it was in a group of others, whether it was in a safe, or candidly, whether it was in the other room. There are two rooms that are issue factually with this particular interaction with the police.
Now, your brother says, and I think this is right, when a car is pulled over and there's someone, and there's reason to suspect a weapon, and I don't know if there's reason to suspect a weapon here, but there's reason to suspect a weapon, even after the person who is going to be arrested is arrested for whatever, the driving offense or having the whatever, that the car can be searched because of the risk that the other people in the car, about whom there's no suspicion, may gain access to that weapon and use it against the police. Do you agree that in a car situation that's allowed?
I don't necessarily agree with the breadth of the question. I agree generally with the principle to some extent. I think I would frame my agreement in the context of the well-recognized motor vehicle exception. Motor vehicles are different than homes, and also hotel rooms, I would suggest to the court, where there's a heightened degree of expectation of privacy in those in a home or a hotel room. The car is different. The motor vehicle is different. The motor vehicle, and I didn't brief it, but I'm sure the court is well aware, there's a tremendous amount of case law that suggests that cars and motor vehicles have different elements to them, different degrees of risk to the police, different levels of mobility, different degrees of temporal stability with how long things may be in them, as opposed to a home or even a hotel room. And a hotel room lies...
The similarities, I would suggest, is that if there's a backpack and a sedan, and it's within a geographic reach, then yes, there are facts there that would say when the police officer takes out this individual who he believes to be armed and dangerous, that there's potential access that could harm that officer from the other three passengers in the car. Makes sense. If it's locked in a trunk, then no.
Different ballgame.
Right? But we know where it is. Right. So if the evidence was at the motion level, that the backpack in that scenario was locked in the trunk, then the judge could say, then the police had no authority to open the trunk, reach in, because they weren't in any risk of danger. But if it was right there in the middle center console, yes, because it's dependent upon the facts. Here, whether it's a hotel room or a car, the reason why we justify in some instances based upon the facts is because of officer safety. Commonwealth's got that right. But in order to show that there's something there, we have to know where that something was located. It's as simple as that. The failure of the Commonwealth, who in a warrantless search has the burden of establishing that it's an exception to the search warrant, requires a finding to link it. So,
I agree.
there you have it.
I agree, and I'm happy to address any other questions from the court, but I think from I guess, from Mr. Smith's perspective with respect to this appellate proceeding, I think it's, from our perspective, it's fairly clear.
I see no further questions. Thank you very much.
Thank you, Your Honors.
The case is submitted. The next matter we will hear is number 25-236, Commonwealth versus Aguilar. And we will hear first from Attorney Moorer.
May it please the Court, Ann Maurer for Mr. Aguilar-Valenzuela. This Court should overturn the conviction below for 3 reasons. First, it was error to link the officer's expertise and training to his lay opinion of impairment to drive. Second, it was error not to give the model instruction, or frankly any instruction, educating the jury about how to differentiate between the officer's expert opinion and his lay opinion. And then finally, there was a substantial risk of a miscarriage of justice because of the weaknesses of the Commonwealth's case and the failure to give any kind of curative instruction.
So can I'd like to jump right in on that first point. Is it, in your view, is it error for a prosecutor to elicit from a police officer witness that that person has been trained in recognizing signs of intoxication?
The error occurs when the expertise and training is linked to the officer's ability to detect impairment to drive.
How could it not be linked if both pieces of testimony arise in the context of a criminal trial for operating under the influence?
Well, that is why the court in Canty instructs the judges to be very careful about instructing juries how to differentiate between these 2 types of opinion testimony that are admissible in these cases. The officers are trained to perform field sobriety tests, for example. But when Officer Sebastian testified in this case that his training to conduct field sobriety tests allowed him to detect people who were under the influence to drive, that created a problem because the jury then could infer that his opinion about the defendant's impairment was expert testimony, which would be improper.
So it would have been proper, I'm just trying to figure out the contours of your argument. It would have been proper for Officer Sebastian to testify, I was trained at the academy in how to administer these field sobriety tests. I administered the tests according to my training. And when I administered the tests, because I've seen drunk people before, non-expert, I concluded that he was showing signs of intoxication.
Well, so for instance, with the field sobriety tests, he could talk about how they are designed to detect I think it's the split attention. And that's not the correct phrase. Divided attention, thank you. And how they are designed to detect whether a person it has control over their physical body and all these signs of impairment. But it needs to be clear that his impression of what he's learning from the field sobriety test is not an opinion about whether the person was too impaired to drive. He's maybe too impaired to perform an A+ on the field sobriety test. But once his testimony, and in this case linked with the prosecutor's arguments in opening and summation, link that opinion about his impairment to perform the field sobriety test to his ability to drive, that's where the error occurs.
So we are, I guess the word would be blessed, with quite a bit of case law on this issue, right? And so Canty and all the cases that came afterwards did one thing very well, which was to tell prosecutors, you can no longer package it all up and then at the very end say, and officer, do you have an opinion about the defendant's sobriety? Yes, his ability to operate a motor vehicle was impaired due to his consumption of alcohol. That is not permitted. And so we have this line. Okay, then what can they say? They can say he was drunk. They can talk about cues of impairment. The word impairment does not get kind of automatically whitewashed, right, out of the testimony. What they can't do is do what the jury's job is, because the jury has to make a decision. So just like a bartender can say, I've seen drunk people 100 times. I've worked for the last 20 years at this bar. I can tell you a drunk person and signs of somebody who's had too much to drink. So can a police officer. They come into contact, the smell, the eyes, the tests of the cues of impairment, right? But what they cannot do is step into the shoes of the jury and somehow then connect it with a closing argument to make it look like Trooper so-and-so is an expert in alcohol, and his opinion or her opinion is that they were under the influence. So therefore, what do I know as a juror? I'm going to go with it's their own independent. And I would ask you just to point to where in the testimony you believe that the testimony somehow created the ultimate issue of fact.
Okay, so I would point to when Trooper Sebastian describes the field sobriety tests in the record appendix at 43. He says it's a test, if that person is good to operate a motor vehicle. So he's saying, I'm looking through the field sobriety test whether this person is too impaired to operate a motor vehicle. He says it shows impairment and things like that. That's at 43. On the next page, he says that he's looking for impairment in administering this test, which he also had already told the jury was designed for him to detect someone who was too impaired to drive.
But where is it in the case law that says he can't say that?
Well, I would point this court to Snow and Dow, which really show that it's not solely the officer's testimony, but the link with the way the prosecutor uses it in their opening and summation. So just one last piece, Trooper Turden, who was the screener officer, he testifies more about his training and experience, which includes his ability to detect people operating under the influence. So his ability, his training is designed to test that ultimate fact, and that was what the checkpoint was for. And then the prosecutor in her opening on page 23 of the record appendix says, we know that driving a vehicle requires such things as mental clarity, coordination, multitasking, and that's what the field sobriety tests are meant to do. For the officer to see if you have that same mental clarity, the coordination to drive that vehicle while you're operating, while you're under the influence of alcohol on the streets here in the city of Springfield. And then in her closing, she says, at record appendix 81 to 82, they were there to see if Mr. Aguilar could operate this vehicle safely on our streets after having consumed alcohol. And she goes on to say that the tests that they used to determine that were based on his ability to perform those tests impaired by alcohol.
Well, that part, I mean, I think that's your strongest argument, is that the prosecutor tried to wrap these tests up as designed to discover whether you are operating under the influence of alcohol or operating while impaired. I'm not sure I really see that the testimony itself says that. I think Tundran, frankly, doesn't even testify about impairment, right? He says, I don't remember what the alternative, he says he's checked, like, it's whether further investigation is needed or something,
Yes,
not
he's a
impairment.
screener.
So that one is not particularly strong in my view. Sebastian is more clear about it. I guess I'm just not sure. I mean, I understand, look, if the Commonwealth's case is, here's an expert in drunk driving, and now with their expertise, they're going to tell you if this person was drunk driving, and then they say, oh, he was impaired, I can see how as a package, you might say, oh, well, at least that it requires that instruction. You know, I don't know if it really is the same as saying all at once, you know, what's not permitted by Canty.
I mean, I would argue just as there's no magic word that is an error, there's also, you know, it's an overall package. And if the prosecutor uses that testimony in a way that sort of blends the expertise.
The closing has nothing like that in it, right?
I disagree. I think the closing argument encourages.
I just read it again last night, but you can tell me where it says something about expertise. I didn't think it had that in it.
Well, I think the section you just mentioned, right, which is I'm not in the appendix, I'm in the jury trial, so I'm at 188 to 189, where the prosecutor says the officers were there to see if the defendant could operate the vehicle safely, and then in the same thing, you know, those standardized field sobriety tests, you heard he did have his field training officer there. So in other words, sort of a stew of they've been trained, they were looking for this, and look, they arrested this guy.
Yeah, and she says something like based on the totality of the circumstances, and the quote is based on scientific, technical, and other specialized knowledge. She's using their technical knowledge to bolster their opinion of his ability to drive.
If we find error, this all comes down to substantial risk, right?
Yes.
Great.
This was not a strong case for the Commonwealth.
I agreed with you until I watched the movie. I agree that it is not as strong as the unpublished cases that you mentioned in your brief, in which there's an accident, for example, or, you know, somebody sees the person driving in a way that indicates that their ability to operate a motor vehicle is impaired because they are failing to operate their motor vehicle. And that is not, other than the creative parking job, there's nothing here about actual impaired operation. But I think that one of the challenges you have here is that picture's worth 1,000 words and the movie is worth probably like 2,000 words. And your client is extraordinarily deliberate in his performance of the 9-step walk and turn test. And so I think, you know, the jury also obviously watched that, and there's all kinds of cases saying, you know, people have their own understanding of what it means to be intoxicated. So I think that's a bit of an uphill battle for you.
I disagree. I mean, I think the deliberate nature, he walked slowly, but he did it perfectly in terms
I'll
of
accept that.
coordination.
Not 100% perfectly.
I do just want to note.
I just want you to know that at least I think you have an argument there. And so in trying OUI cases, if there's a if there, even though the instruction says you don't need to drive erratically to be found guilty under the influence, if there's absence of erratic operation, the absence of an admission of a large quantity of alcohol, all those tests often create really good fodder for a good defense attorney about balance and back issues and wind and nervousness. So those are triable issues. It's not a dead winner for the Commonwealth. I think you're absolutely right on that one.
Yeah, and frankly, like, there was no, I argue that they should have given the model jury instruction 3, but there was no instruction to cure this problem. There could have been the, Canty instruction.
What did the judge gave model jury instruction, supplemental model jury instructions 1 and 2, but not 3? Is that right? Or 1?
1 was given. The field
Was
sobriety
it
test.
requested by anybody, or the judge just sua sponte as part of the ordinary course
It was requested,
by?
the defense.
Wait, what's the it there?
The field sobriety test instruction.
So
That was given,
supplemental
yes.
1 was explicitly requested, supplemental 3 was not requested.
So this is not in the record appendix, but on page 4 of the transcript, there's a motion in limine argument.
Wait, don't we have the whole transcript?
Yeah, we do.
Okay.
It was not in my,
Okay.
so the defense asks for an instruction based on the weight case. I think it's clear that he does not know what the model instructions say. The judge reads to him the model instruction about field sobriety test expertise, and he said, oh, that's good, basically. So he wasn't asking, it wasn't as if he read the model instructions and asked for number 1 and failed to ask for the instruction I think he should have asked for. I don't think he read the instructions at all. So it was a failure by the defense to ask for that third instruction.
What is the weight instruction? What does that mean?
Well, weight is a case that's cited in both of our briefs. I can get the citation.
It's not spelled weight,
Oh,
is
it's
it?
W-A-I-T-E.
Oh, I see. It
believe,
just says the word weight, W-E-I-G-H-T.
in the transcript, yes.
Okay.
Yes, which was about expertise directly related to the field sobriety test as opposed to impairment to drive. So he's asking for an instruction based on that case, not having read the model instructions.
Okay. Your time has expired.
Okay.
And I see no further questions, so thank you very much.
Thank you.
Excellent argument. We will hear next from Attorney Safransky.
Good morning, Your Honors. May it please the Court, Carrie Safransky Curley for the Commonwealth. Your Honor, I think you've touched upon a lot of the points that I wanted to make. I don't think that there was any improper testimony here. We really don't have anything in the testimony from the troopers that actually opines as to the ultimate issue here.
Let me ask you this. I understand testimony being permitted that says you are inebriated or you are drunk. This now says impaired. And I guess impaired can be used if it means, well, actually, I'm not sure. Impaired does not really mean drunk.
Your Honor, what's not permitted is the ultimate issue, impaired.
I understand that, but I'm trying to figure out, since driving while impaired, I mean, we call it drunk driving, right? But it's really, driving when you've consumed enough alcohol. I don't remember what the words are exactly. If it's not from a blood test, it's, so that your ability to drive is impaired by intoxicating liquor. It's not, have you had one drink? Maybe it should be, but it isn't, right? So I'm just wondering if impaired gets a little closer to the ultimate issue than inebriated or drunk.
I think that could be possible in some circumstances. In this case, Your Honor, it's pretty clear that it's being used in place of inebriated or intoxicated. There's no inference here at all from the trooper's testimony in any place in the transcripts that I can find where it could be taken to be used as impaired impaired ability to operate a motor vehicle. It's very clear, I think, to the jury that the way they're using the word when they do use it is in place of the word inebriated or intoxicated.
Well, I think if I could just follow up on Justice Rubin's question, this is a problem that was caused by the prosecutor. The prosecutor is the one who uses the word impaired over and over again. She uses it in her opening. She uses it in her questions. She repeats it. And I would just suggest to you that even though Canty says there are no magic words, impaired is a lot closer to magic, or maybe black magic, or the opposite of magic, than intoxicated or drunk or buzzed or wasted or inebriated or any of the other plentiful words we have in the English language to describe being under the influence of alcohol. And I would suggest that this would be a much tougher appeal for this defendant if one of those other words had been used instead of impaired, because impaired is a word that by its nature asks for a consequence. Impaired to do what? Impaired to drive. So you're pulling in this legal conclusion, maybe not deliberately, but I think there are better words.
I don't disagree with you, Your Honor. Ideally, another word would have been used, but again, looking at the circumstances here, looking at the totality of the testimony from the troopers, I don't think there's anything extra added here that makes it an implication to the jury that what we're saying is that the defendant was too impaired to operate that motor vehicle.
Well, the prosecutor does suggest in the opening at least that that's what, maybe in the closing too, but in the opening at least quite clearly, that that's what they're looking for, that that's what these officers are checking for. Are you too impaired to drive?
Your Honor,
So let me just ask you this. I think what you're saying is that's fair game, still under the case law. So in other words, the crime is not drunk driving, and prosecutors attempt to ensure that they're meeting their burden, which is that their ability to drive, the defendant's ability to drive a motor vehicle safely was impaired due to ingesting an intoxicating liquor, correct?
I think that's right, Your Honor, and I think that
So I wouldn't want to suggest that your prosecutor should deliver on a promise of that they have to show drunk driving and confuse the jury. It's the line that cannot be crossed is when, I think you understand it, is when we take all this expert but not expert training and testimony and provide the jury with an opinion that mimics exactly what they need to do, because this is a crime of opinion, right? The jury has to come up with an opinion, not a, did this happen? It's an opinion that their ability to drive was impaired. So it's just that testimony that you have to be careful of, that somehow it's not so highlighted as to give the jury the belief, without even the testimony, that these officers, in their opinion, can just be stamped.
I agree, Your Honor, and I think in this case, the troopers were very factual. They're not offering opinions. I think that counsel, my sister's argument is really this link, because there is nothing strong in the trooper's testimony where they're offering opinions about anything.
Can I ask you about the effect, though, of what the prosecutor said they were doing?
I'm sorry, could you repeat that, Your Honor?
The effect of what the prosecutor said the officers were doing. I guess I can agree with you about their own testimony. But the prosecutor said they were looking for impaired driving, not having the ability to drive is what they were looking for. So let me start with this question. Why shouldn't the judge have given supplemental instruction 3? Right, supplemental instruction 3 says that it has to be given, quote, if the Commonwealth portrays a police officer as an, quote, expert, unquote.
Your Honor, I think the judge didn't feel that that line was crossed here. Nobody suggested to the judge that that line was crossed.
Well, but the judge was going to give and did give supplemental instruction 1, sua sponte, right? In fact, although it's asked for by the defense, they withdraw their request once the judge says, well, I give that instruction. But why shouldn't the judge have given the supplemental 3?
Your Honor, because the police officers here were not portrayed as experts. When the prosecutor is speaking about the training in her opening, she's describing for the jury or describing what's going to be elicited from the trooper as far as what type of training they receive to educate the jury. And this is a roadblock case, so I think it's especially important that they have some context for step 1, clue 2, and you can see on the video them writing things down, making check marks, things of that nature. So I think it's just giving them context as opposed to portraying them as experts. If there's nothing further, I would rest on my brief.
Yeah. Nothing? Thank you very much. Very good argument as well. So the case is submitted. We are going to take our traditional mid-morning break. So we will return in 10 to 15 minutes to hear the remaining 3 cases. Makes it weird.
Closing session, please be seated.
Welcome back. We turn now to our fourth case of the day. This is an impounded case, so of course we're not going to use the names of the parties. It would be better to use things like older child, younger child, etc., mother, father. I gather the appellees are splitting their time half and half, 7.5, 7.5. And the case is number 25232, Department of Children and Families and Another versus Mother and Another. And we will hear first from Attorney Hopple.
Good morning, members of the panel. May it please the court. My name is Natalie Hopple, and I represent the appellant mother in this appeal. Your Honors, I'd like to briefly address my jurisdictional arguments regarding ICWA before turning to the permanency plan, if it pleases the court. Your Honors, a conditional reversal as part of a published decision will both acknowledge that there are judges in the Commonwealth, like Judge Souza in this case, who comply with ICWA. However, the new juvenile court rules, which went into effect on August 5th of this year, specifically Rules 9 and 14, do not explicitly direct the lower courts to comply with ICWA's regulation 25 CFR 23.107, which provides that state courts must instruct the parties to inform the court if they subsequently receive information that provides reason to know the child is an Indian child. The last sentence in this regulation underscores the ongoing jurisdictional application of ICWA.
What information, was there information received here?
Your Honor, there was no information received
Okay, so
here.
what's the point of this?
Your Honor, the point is that ICWA is an...
If we retain jurisdiction and remand so the judge can properly ask the parents again if they're Native American, or if the child has Native American heritage, a member of a tribe, you know, whatever the requirements are. The answer will be no, obviously. You don't have any reason to think otherwise, and then we'll get the case back. I'm not sure, right? I find it unlikely that we're going to vacate the whole order and send it back for a 1-minute hearing. So what's the point? Isn't this, if it's error, why isn't it harmless? We know the parent's heritage, and because of another child in exactly the same situation. I'm just baffled by, you know, how much space you spent in what seems like a case, you know, with substantial questions on this.
Yes, Your Honor. Understanding, I just wanted to briefly address why I spent so much time in my briefs and in argument on this issue is that it's important. It's a federal statute that preempts state law, and I will move on. Thank you, Your Honor. Your Honors, turning to the 29B plans, a principal purpose of this court's exercise of jurisdiction is to clarify the law. On behalf of my client, I urge this court to reverse the lower court's decisions approving the goals of adoption for these children because an evidentiary hearing under adoption of Parker did not occur in the lower court.
Has there been another redetermination hearing?
No, Your Honor, there has not yet been another redetermination hearing. There is one scheduled.
Isn't it every 12 months, and wasn't the last one in October of last year?
I'm sorry, Your Honor, are you questioning whether there was a permanency hearing or a review and redetermination?
Oh,
hearing
I
of
see.
further
No,
trial?
I mean another, I guess, permanency hearing.
Yes, Your Honor. So in terms of there has not, I believe there has not yet been another permanency hearing within that 12-month period. It's been extended. There's also a review and redetermination hearing, and my understanding is that the lower court intends to hear both of those together, which is entertained by the permanency rules.
So can you point me in your brief where you identified this issue that you just spoke of, which was that we need to vacate this order because of the lack of an evidentiary hearing for the goals of adoption?
So, Your Honor, my brief, unfortunately, because trial counsel for mother at the time of the permanency hearing waived the evidentiary hearing
How can you
requirement.
waive an evidentiary hearing? How can a judge determine this? Doesn't the judge have to hold an evidentiary hearing?
Your Honor, I would actually offer to the court that the permanency rules do not explicitly require that an evidentiary...
About the Constitution?
I believe, Your Honor, that's what I am arguing, is that under due process, where there were...
Where's that argument? Because, so trial counsel waived, and you say, maybe or maybe not. Where is it in your brief that you argue some sort of constitutional violation of a determination without an evidentiary hearing? Because if it's there, honestly, I missed it, and I want to know where I missed it.
Yes, Your Honor. It was not raised in my brief because trial counsel waived it.
Okay.
However, in terms of where there were conflicting facts and the constitutional, the due process requirements here, Your Honors, I guess I can step back and let you know that the permanency rules do not explicitly require lower courts to conduct an evidentiary hearing. In this particular...
I don't see what difference that makes. I just don't see what difference that makes. How can you approve an adoption plan? Here's some questions I have about facts. Who injured the older child? How did it happen? Was the mother aware of it or not aware of it? Is she lying? Is she telling the truth? How can you decide whether to adopt or reunify without at least coming up with answers to those questions? Now, the answer might be, we don't know, so it's too dangerous. But with no evidence, you can't do anything. How could you answer those questions? I mean, the court says that the mother has gained no insight into the injury. How do we know? There hasn't been any, she wasn't asked to testify about it. So how do we know?
Your Honors, there was a first trial in this case that took place.
Yes, the second trial was looking for changes from the first trial, right?
Well, Your Honor, the first trial took place. There was a determination of unfitness. There was a declination to terminate mother and father's parental rights. Then there was an interim permanency hearing, and there has not been a further trial. So the interim permanency...
I'm sorry, the permanency hearing finds, as a fact, as I read it, the opinion, that the mother has gained no insight. It also says that she has not complied with the program outlined in the previous order. Maybe we'll talk about that or maybe not. How does the judge know she has gained no insight?
Your Honor, that would be precisely what I was prepared to argue before this court today.
Yes, but you didn't put it in your brief.
Yes,
but
Your Honor.
I just can't understand how, what it means for the, I mean, I'll ask opposing counsel, maybe they have some answer to this. I just don't understand how a judge can find anything without any evidence in the record. But, all right, and let me ask you this. You say in your brief that this is a very important matter, this placement hearing, because now reasonable efforts don't have to be made. And you cite an unpublished opinion and then a bunch of cases without pinpoint cites. I read my way through at least one of them, and it doesn't mention anything about that. So do you think I thought reasonable efforts had to be made at all times when DCF has custody. I thought that's what the statute said.
Your Honor, my understanding is that once a goal of adoption has been approved, or once a goal of adoption has been identified, that the reasonable efforts does not need to be...
Okay, what do you mean your understanding? From where? Do you have a case? Not the unpublished case.
It would be 119, Section 29B, Your Honor.
I think I read that, and it doesn't say anything about...
I believe the unpublished decision cites to both of those statutes, 29B and 29C, stating that once a goal of adoption has been identified, the department is not required to make reasonable
The statute
efforts.
says that?
Yes, Your Honor.
All right, I'll look.
Your Honor, if I may focus on the lower court's decision after trial. The lower court after trial made certain recommendations as well as finding that the goals of adoption, they were both rejected, and the lower court set the goals of reunification. But what had happened in terms of DCF internally, or the department internally, is that their goals remained adoption. There was a foster care review which took place in March of 2024, at which time the foster care review panel was in a position to have the department change their internal goals from adoption to reunification. What my brief attempts to bring to the court's attention is that we had a court approved plan of reunification, but the department did not follow through and convene an internal permanency planning conference internally to change the goals from adoption to reunification. And the department is arguing that they've been engaging in concurrent planning, but what I would posit to the court is with the transition plans that were filed into the court record, they were merely visitation plans, which the department is already obligated by regulation to do. So after the first trial, the department took no affirmative steps other than implementing visitation plans towards reunification, which meant that the department did not comply with the court's order. When we get to the permanency hearing, the lower court declined to hold the department to the standard it set forth in its post-trial decision, in which it stated that reunification was supposed to be the goal for these two children.
But that's the first step, isn't it? I mean, it doesn't make sense to come up with a 30-step plan necessarily when first we have to have, like, showing up is important, right?
Yes, Your Honor.
To be able to continue the plan. So had the parent shown up, had mother shown up, then it would have led to increased visitation. It would have led to, and then they continued it again for another 6 months and said, okay. And the plan then to be having overnight and more unsupervised visits. And so it doesn't seem to make much sense to me that the department would go on to like, well, mother didn't show up, but then we'll plan some other thing that requires 5 more steps.
Your Honor, if I can answer your question, what ended up happening at trial is the lower court identified that the department unilaterally cut off visits between mother and the children. Mother had then began to see the children. So a reunification plan and a transition plan is part of a reunification plan. If mother's already visiting with the children, then what would have been the harm of setting a tentative reunification date with a set of standards in it?
There would probably be no harm, but your argument is that they didn't do enough. And when my suggestion is when mother can't meet step 1, okay, well.
I can offer to the court that mother did meet step 1. At the time of trial, mother was in compliance with her action plan. She was not seeing the children as much as she should have been. After trial, through to the foster care review in March of 2024, the foster care review panel in the foster care review identified that mother was in compliance at that point in time with her action plan, and she was seeing the children. The department didn't follow its own policy by setting down a reunification plan. I detailed in my reply brief what a reunification plan usually entails in the department's own policy. That type of plan was never envisioned by the department.
Can I ask you this? Am I correct that immediately after the court's 2023 order, visitation resumed or increased?
I don't know if it was immediate, but thereafter, yes, it did. It resumed and increased.
Not in May of the next year,
no, it
but
did,
right away.
Yes, Your Honor.
And counsel had no objection to the amount that was given, or you never filed a contempt motion or anything like that, saying, look, this hasn't happened properly. Is that right?
Not at that point in time, Your Honor. What was supposed to happen is that mother and the department were supposed to come together and develop a reunification plan. Instead, we ended up with 2 transition plans.
Well, if the goal was reunification, they should have had a reunification plan, right?
Correct, and that did not happen. It was
now, the judge didn't exactly order a change of goal, or maybe the judge did. I don't understand what these recommendations are. I don't know under what authority a judge can recommend things. I would have thought that would not be what a court does.
I think, Your Honor, what the court did do as part of their decision is found that the goals of adoption were not in the children's best interest.
The goal or the plan?
The goals of adoption were not in the children's best interest, and then made recommendations.
I thought the judge found the plan of adoption was not.
The plans of adoption were not in the children's best interest, and that reunification was in the children's best interest. But the difficulty is that if the department is maintaining an internal goal of adoption, then they're engaging in what's called concurrent planning. So they're driving down.
Is that lawful to begin with?
I would suggest to the court that that is problematic, that the department really needs to pick a goal and carry out that goal. And if anything, if they're trying to drive down both lanes of the reunification and the adoption highway, that both of those reasonable efforts directed at those 2 goals are going to be less than, not sufficient to meet the reasonable efforts determinations that the court validated at the permanency hearings. And Your Honor, I would just point out that if a parent prevails at a termination trial in terms of adoption not being feasible, why wouldn't the department change the goals back to reunification? Shouldn't there be a reset at that point in time? The statute isn't silent saying that if you go to trial, maybe you're not
No
fit.
one brought a contempt action saying that they had failed, right?
Against DCF.
I don't believe during this period of the record there
Okay,
was a
so they're
contempt.
not doing what you think they need to do, and you wait till the permanency hearing to raise this issue?
What I can let the court know is that one of the issues that interrupted bringing this to the court's attention is that mother terminated counsel, had success, went through about 20 days without counsel, then had successor counsel. Successor counsel filed an objection, then we get to the permanency plan. So there was some disruption in terms of mother's representation towards confronting the department with the transition plans, which again, I would direct the court to the language in the transition plans. They're providing for supervised visitation or unsupervised visitation at a visitation center. Those transition plans, I could have rewritten them into one page.
I'm sorry, and what's the problem with the unsupervised visitation being at a transition center, given the violence that was done to the older child when in the care of the mother previously?
And I think in the record, Your Honor, it does suggest that father was the one who was on trial for those injuries, such that there was nothing that showed that mother...
His case was null prost.
It was null prost, yes, Your Honor, but he was the parent who was presumably...
I see no finding of fact anywhere.
Yes,
And
Your
by
Honor.
the way, of course, without knowing the facts, I can't know who's responsible. As I said at the outset, I have no idea why the mother doesn't know or said she didn't know how the injury occurred, but both parents are responsible for the child.
We do not deny, mother does not contest that she's responsible, but how can mother know what happened if she wasn't there? And I think
I
that's...
don't know if she wasn't there because there's no finding of fact. I don't really know what happened at all.
Yes, Your Honor, and that is part of the deficient record here. Thank
All
you,
right,
Your
your
Honor.
time has expired. Thank you very much. Very good argument. We will hear next, I believe, from Attorney Braithwaite.
Thank you, yes. Members of the panel, may it please the court, I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families. What's under appeal today is not mother's unfitness as adjudicated in November 2023. She didn't appeal that finding, nor is this an appeal of a termination decree. What's under appeal is a 29B permanency hearing decision, and the question before this panel is whether the trial court abused its discretion in finding in October 2024 that it was in the best interests of the two subject children to approve a plan of adoption. I am asking you to find the court did not abuse its discretion and to affirm the permanency goals of adoption approved by the court.
One basis of the court's decision, I mean, I said I was going to ask you about this, so
Yes.
one basis of the court's decision was that the mother hasn't gained any insight.
Yes.
How does the court know that?
So the court was clear that while the parties did not request an evidentiary hearing, the court reviewed argument of all counsel, reviewed the permanency plan dated May 2022, 2024, DCF court report dated September 30, 2024, and court investigator reports. And so in other words, the court
Were
did
those
have to-
moved into evidence?
They were submitted in accordance with the 29B hearing standards, and the parties all had an opportunity to object.
What is a 29B hearing standard?
Well, so I believe, if I'm not mistaken, the 29B standard would be that you can have, well, you're required to have a permanency plan, which was put in, and then the DCF court report dated September 30, 2024, as I understand it, was not objected to, and the
I'm
court...
not asking if it was objected to. I've never heard, except in contempt cases, we have some cases holding that in contempt cases, the court can proceed on representations only. That's the only thing I've ever heard of before where some big decision is made by a court and there's no evidence in the record. For example, are the children adoptable? Does that have something to do with approving an adoption plan? I have no idea. There's no finding on that. There's no evidence about it, and so forth.
So a permanency plan report is required to include information about the progress of the children, the home that they're in, the efforts towards
I've
adoption.
read what was submitted. I think I've read what was submitted as the court investigator's report, maybe.
So the
And it says
29B
nothing, I saw nothing here about where the children are, or what it's like there, or whether they've moved in the year in the interim, nothing.
The 29B permanency plan does contain, it's required to contain information about the children's current functioning at the time of the plan. I don't have the site to that in front of me.
What's the date of the permanency plan?
It was dated May 22, 2024.
Okay, so 6 months later, there's a hearing and a determination, and we know nothing about what has happened in the 6 previous months.
I would imagine that that's why the court report was accepted, but I can't attest to
But
that.
the court
of
report
course.
doesn't say anything about the children's current circumstance.
I think that while I would agree that that information should have been more current in the permanency plan, I would also think it's important to note for the court that while it is a big decision to say that adoption is in the best interest of the child, I want to be clear that that permanency plan approval in no way impacts what's ultimately found at a termination trial. So
Does it impact whether you have to continue making reasonable efforts toward reunification?
it does, yes.
Okay, so it's a pretty big deal then, I guess.
It is, and
Because
it's,
if you don't make any efforts toward reunification, there isn't going to be any reunification, right?
if the evidence before the court at the termination trial was such that it was not in the best interest of the children and the
How
department...
can it be if you're not making any efforts, you're the custodian, you're not making any efforts toward reunification, so the child doesn't even have to visit with, or children don't have to visit with their mother, and I'm not saying they should or they should, I have no idea. But to say this isn't a big deal, it seems almost determinative of what the outcome of this case is going to be.
So I don't mean to say it's not a big deal, but what I do mean to say is that the department would retain the burden at trial of proving...
Yes, but it'll be easy. You've created an easy burden for yourself. Just make sure the children never see the mother during the ensuing period of time, and then you can go in and say, well, they haven't even seen her for 3 years.
Well, while there's no longer reasonable efforts at reunification requirements, I do believe there are statutory requirements when a child is in the department's care and has not had the parental rights have not been terminated. There is some minimal amount of visitation that's required, but I do hear Your Honor's point.
Let me also say, I just looked at the statute, and I had not, because it's not cited in the brief, I hadn't known which statute. 29B says there has to be a finding that further reunification efforts are not required, and I didn't see that in the judge's order.
I believe in the judge's order, and I could go back to it, she does, well, can I detail what I think she viewed as the evidence? Can I speak to that a bit?
Yes.
Because I do think it's of concern to Your Honor, appropriately, how the judge reached this conclusion. And I think while there certainly were not orders issued in November 2023, the judge was very clear that the recommendations would shed light on her
And what's the
concern.
authority for a judge issuing recommendations?
Well, the judge issued an order, and the authority is that she was communicating what her concerns were, and so it would be in the best interest of
I'm
parties.
asking what authority there is for recommendations. See, if she issues an order, then everyone knows what the order is. Someone could challenge it and say, that's no good. If it's merely a recommendation, how do you challenge it? You can't challenge it, it's just a recommendation. And yet, if you don't do it, right, I just don't understand it. It seems uncourt-like, like not a judicial act to recommend things.
I think it's actually more consistent, even though we're not usually seeing it in this context, with what we see in child welfare law, where action plans are not orders. They're guidance issued, they're actually developed.
CF issues action plans, not courts.
No, but courts, when they assess unfitness, they're looking at compliance, and they're looking at whether those action plans were created in such a way that they were designed to help the parent overcome their shortcomings. And if the parent doesn't utilize them or doesn't benefit from them, the court is authorized to look to that as evidence of unfitness. And I think here there's something similar. The court was identifying that and much like with Carlos, the court was identifying there was clear and convincing evidence of unfitness, and I even find mother's unfitness seems likely to continue into the indefinite future. However, I don't find it in the best interests of the children, and she communicated what would, in order, as she put it, I think, to be of service to the parties. And it could have been, that whole order could have been appealed, but it wasn't. But I understand an order versus guidance is different, but in order to guide the parties about what might help reach resolution at the next hearing, she expressed expressed what she thought would need to happen in order for mother to have the children reunified. And then in reaching her conclusion at that permanency hearing, she was looking at what had been done in order to support mother in reaching that reunification, and whether or not mother had taken advantage of or availed herself of those opportunities, and found that she hadn't. I mean, the court was very clear.
Yes, without any evidence in the record. But I've taken up all your time, which is no good because I have two fine colleagues here who I've dominated.
Maybe fine, but I have nothing to say.
I just want to make sure I heard you correctly. Are you suggesting that our review is for abuse of discretion as it relates to the approval of a permanency plan?
Yes, the standard of review here is very limited. It's explicitly spelled out in 29BE. It's limited to whether, based on the record, there has been abuse of judicial discretion. Thank you very much, Your Honors.
Very good argument. We will hear next from Attorney Sorokin Butler.
Good morning, Your Honors. Deborah Sorokin Butler on behalf of the minor children. It's pretty rare that Beacon Hill gives us a clear directive. But here in 11926E, the statute itself states, the scope of appellate review is limited to abuse of judicial discretion. And there's relatively little case law on that, so I looked for guidance to Lonergan-Gillen versus Gillen. That is to say, did the judge look at what all her options were? And she did. And one of the facts in this case, which is consistent through the record and in my brief, is that the older child has been in the same placement now for almost 5 years.
There's no finding of fact about that placement anywhere in anything any judge has done, right?
No, that's not correct. Where you can find it, Your Honor, is in findings and order, in what went into the record at the 29B as Exhibit A, which is the order of adjudication and findings, in which on page 56 of my addenda, the record states that the older child has been placed with his maternal aunt since his removal, and the younger child has been placed with his paternal great aunt since June 21st of 2021, which would have been when he was 2 days old.
Is that the findings of unfitness?
That's the findings after the first best interest hearing.
So a year before this hearing, it was found that they were in some placement. I said
Yes.
there was nothing saying that they're still in that placement. There's no fact saying that it's going well or not well. Now, this isn't a termination case, so, you know, she's not approving the adoption, but she is approving a plan of adoption.
Because the same judge had heard the best interest hearing, and under the way the juvenile court operates, hears every status, every motion, and the 29B, this judge was well aware of what the placements were and whether or not they had changed.
Did the mother have a chance to cross-examine anyone who testified about it?
Anyone they asked to cross-examine. I didn't see that
At what? There was no hearing.
I didn't see that my sister brought in an ineffective assistance claim rather than an ICWA claim.
Well, it's not, her brief goes well beyond ICWA.
But the burden...
And I'm not sure, I mean, I don't know if we talk in terms of structural error. How can you approve an adoption plan with no evidence? I just don't understand that. They may have a rule that allows it, but that doesn't make it okay.
Well, if this court chose to strike down the rule or to strike down the statutory scheme...
There's a statute that says don't hold a hearing? I find that hard to believe.
There's a statute that says that this administrative event is entitled to review for abuse of discretion.
Error of law is an abuse of discretion always, right?
Pardon me?
An error of law is an abuse of discretion, always.
I do not see an error of law in approving a detailed plan.
Without
The errors
any
of law
evidence.
I do see with these permanency hearings is when they hold no hearing at all and they rubber stamp them all.
So your point being
You
because-
basically get what you put up with in a 29B functionally in the juvenile court.
I'm not interested in functionally. I'm interested in protecting the rights of the children and the parents. And I don't see how without a hearing, without evidence, you can decide what plan to approve. I mean, of course, usually we only see plans. These are appealed. I don't know why this came to the full court. Usually these are interlocutorily appealable to the single justice. And instead, here we are a year after the hearing, looking at it.
They were able to do that because General Law 119 says that an objection and appeal to a 29B plan goes to the full bench, but the scope of appellate review is limited to abuse.
Well, they can also interlocutorily appeal it. I'm not saying we don't have jurisdiction. I mean, I've been here over 15 years. I see DCF cases every single time I sit. I have never seen an appeal from a permanency hearing before, ever. So, as part of a panel. I don't know if I might have seen it as single justice, but.
And I think
Can I just ask you a question?
Of
Would
course.
your position be different? So in other words, your position is that there's nowhere, and co-counsel to some degree, is that there's nowhere that requires an evidentiary hearing. However, that perhaps there'd be an argument that the judge abused her discretion if mother said, I want to call witnesses and I want to cross-examine, et cetera, and the judge said, nope, I'm determining this on the papers only. That there'd be a stronger argument that that was an abuse of discretion, where here, mother's counsel waived argument, agreed, here are the documents, judge, you decide whether this permanency plan should be approved. Is it different?
Well, I think the answer is that what this judge did is listed all the possible things she could conclude and analyzed them based on what she knew from the hearings she had heard and the evidence she was aware of in the case. If the judge had simply said, well, the goal should be adoption, we're done, that would have been an abuse of discretion. What she did here is say, my counsel was not followed, these negative events happened, adoption is an appropriate goal. And what she knew is that mother had filed a review and redetermination, and there was going to be a best interest hearing and a full hearing. At this point, it was bumped from December to February. I've been monitoring it. But the judge actually looked at what all her options were.
December of this year?
Yes, it was originally going to be December of this year.
But the judge,
And then the
judge
court, for
approved
reasons
the
not
plan.
known to me, the plan does not determine the outcome of the trial. And I have,
Are reasonable efforts being made to reunification?
yes, what is going on now is there are two workers. There's an adoption worker and a parent's concurrence worker.
Right
Visits
now,
us- yes.
after the approval of the plan?
Yes. The department is required by law to do concurrent planning unless there has been a murder or a termination of a previous child under ASFA and under Massachusetts law. So what constitutes sufficient or valid concurrent planning, that's a problem. And I fight it valiantly in my trial cases.
I'd like to understand, we heard from the Deputy General Counsel of DCF that they are no longer making efforts toward reunification. You're saying they are.
There's still a reunification worker and an adoption
Are
worker.
they making efforts toward reunification? I don't care if there's a worker. Is the worker doing something?
To the best of my knowledge, yes. In my case, what I do when I represent children is I attend some of the parents' visits. I review, even on appeal, what's in the current court, what's going on. That's how I could tell you when the best interest hearing was.
How
going
often
to be.
is the parent having visits now?
She's having visits that are weekly and multiple hour still. But what DTF does, and I would know because I'm still in the trenches even though I do appeals, is they have two workers. They have an adoption worker and a parents worker. And what seems to make the greatest difference is, and I tell every client this, you need to have the worker like you. Now, should it be that way in the best perfect world? Well, no. But does this case still have two workers? Yes. Is mother still able to see her children with more frequency than I see in many cases? Prior to Walt and Rashida, whenever the department changed the goal to adoption, it would drop visitation to 1 hour a month. This mother is getting more than 8 hours a month still at this time. So my problem had been, what is the standard of review? What is the scope? And I have a statute that says abuse of discretion.
So
And then in terms of what constitutes abuse of discretion.
The judge finds that the mother in the year between the original hearing and the second hearing has gained no insight into the causes of the injury to the older child.
And you know,
Is that a finding of fact?
what is it based on? Probably.
I didn't ask you that. I asked if it's a finding of fact.
In this
The
case,
mother
in this
has gained
record
no
that I was
insight.
given, I don't know because there was no medical records.
So you're saying it's an unsupported finding of fact?
I'm saying that the judge came to that conclusion, but I can't tell you why.
Okay. All right. Thank you very much. Very good argument. Oh, can I ask you, have you seen your clients lately?
I saw them last month.
And how old are they now?
They are, I hate to say it, but everybody looks young to me now.
Well, they're little children, so that seems
They're little
good.
children, so they are both still daycare aged.
So under
So,
6.
Like 4 and 6. I know what their birth dates are, so that helps.
Okay.
We probably do too, if
We
we were
probably
to look
somewhere,
at it.
or we could put our hands on it.
And,
Thank you.
and they know their mother, and they like to see her.
Okay. Thank you very much. Very good argument. The case is submitted.
Thank you.
The next case is number 25. Get either new eyes or new glasses. 25301, Watkins v. City of Boston Board of Appeal. Do you want my robe? That would be hilarious. We will hear first, well, first we'll wait for counsel to get to counsel table, and then we'll hear something. We will hear first from Attorney Timmons.
Thank you, Your Honor. Good afternoon. May it please the court, Attorney James Timmons for Brad Watkins, a plaintiff who had his zoning appeal dismissed for lack of standing, notwithstanding the presumption he enjoyed as a direct abutter. I'm addressing today two of the reasons that were given for the dismissal. One is it relates to density, and the other one relates to an alleged, I'm going to call it, shadow light study. The reason I'm focusing on these two is that in order to appropriately challenge standing, it's up to a defendant in a zoning case to either establish as a matter of law the zoning code doesn't address the agreements that the plaintiff's complaining of, or alternatively, they have to submit credible evidence sufficient to rebut the presumption. In this case, it's pretty clear for a few reasons that the zoning code, whether it's the Boston zoning code or the Dorchester neighborhood district provisions, both address the issue that Mr. Watkins complains of, which is density and overcrowding of his lot. So for that reason, the plaintiff in this case mounted an attempt at rebutting the presumption primarily through the work of a consultant, a Mr. Spang. And I challenge much of what he did, but a couple of the highlights on that are as follows. First of all, in paragraph 28 of Mr. Spang's affidavit, he concedes that this new wing that's going in on the property that's at issue in this case, that it's being built on open space. He refers to it as green open space. So he is conceding that the interests that the Dorchester neighborhood district specifically addresses are in play here. Now,
so is your contention that, I mean, first of all, as a practical matter, if one is building something new, it's hard to build that on anything other than unbuilt land, right? So so if you take your argument to the next logical step, are you contending that the plan prevents any new building in Dorchester?
I believe the code does not prevent any new building. What it does, however, is it protects, there's a mandate in it to preserve open space.
Okay, but can I ask you this? What aspect of, so we're only here because this required several variances. Which variance caused it to close off open space more than it could have done as of right? If they could do it as of right without a variance, they can build it, even if it wrecks your open space, because we're generally not entitled to open space that's someone else's private property, generally. So I think you have the burden ultimately to show, if it's rebutted, but I'm inclined to think there's enough to rebut the presumption, but you have to show that something that they did, that the zoning variances did, invades one of your protected rights. So which variance makes this building close off more open space than they could as of right?
The Dorchester neighborhood provides for an FAR, floor area ratio
Sure.
of 0.5. In 2003, when Neighborhood House received its initial zoning relief to construct what is now there today, they exceeded the floor area ratio of 0.50 and went to 0.67%, a very substantial jump, and one that the zoning board at the time said, we don't want you to exceed a 25% increase in floor area ratio. Because you're correct, Your Honor, that if they could do something as of right, then we wouldn't be here today. However, it's the floor area ratio that protects, because that's the ultimate test of density in a neighborhood.
Well, I don't know what floor area ratio includes. I've been in buildings that have several basement floors. Presumably, floor area in the basement floors would go into floor area ratio, but it wouldn't change anything above the ground. I don't know if the footprint is larger. I don't know if it's because it has 5 stories on one part of it. Like, I don't know how the floor area ratio closes off the open space. Is there evidence about that?
Oh, certainly, Your Honor. The primary evidence is the fact that, as Mr. Spang concedes, they're building in what is now open space. So they're going to take...
Of course they are, but they're allowed to build some things there. I'm asking how the increased FAR to 0.88, how that makes this close off more of your client's open space than they could do as of right. So, for example, if all the additional FAR is on the far side of the building, not on Queen Street, but on the other street, I don't think you'd have much of a case that it affected Watkins. So I'm just trying to figure out in what way FAR, the increased allowance of a higher FAR, in what way that affects your client.
Certainly. Well, first of all, if it were on the other side, which is where the whole project began, we'd be fine. But Mr. Watson's sitting there in that neighborhood in a single-family home, well, 2-family, but he lives in one house next to this school, and he basically squared off with neighbors on Train Street who won the battle, and everything got moved over to the Queen Street side of the project. Now, to your question, because of the FAR exceedance, they're able to go higher than they would have otherwise. And by way of example, if someone were to put a single-family home there, which another thing the DND and the Boston Code talk about is maintaining the fabric of the neighborhood, if someone put a single-family home in that exact same spot, built on that open space, it would be an entirely different impact. This is a massive brick building. It's got the same number of
They're allowed to build a massive brick building. Even with, as of right, they can build a massive brick building. It just can't be this massive.
Correct. But we're here on this one.
Okay, so my sense is that the 5-story part of this is far away from the Watkins property. Is that right?
No, Your Honor. There's a picture of the driveway, looking down the driveway, and the 5-story building is right in the backyard of Mr. Watkins.
But I thought this new thing was going to have like a different gymnasium or something that had 5 stories. Maybe I'm forgetting it.
No, you're correct, Your Honor. They're going to add a gymnasium, and that's not an issue in this case, and not an issue that Mr. Watkins would be challenging, because although it was moved, it didn't come all the way around to impact his home. This is directly next door.
And the FAR isn't for the combined project? It's just for the thing directly next door? I thought it was all one project.
No, it's all one project. That's correct, Your Honor. But the classroom building itself has been moved around. It's right next to Mr. Watkins.
If they didn't build the gymnasium at all, would the classroom building be conforming?
Well, perhaps if they moved it back where the gym is now going, if that's
well, I mean, but it meets the setbacks.
But that's a little amorphous, Your Honor, because it's one thing to be, it meets the side setback. They tout the fact they meet the rear setback. Well, that's no big deal because they're connecting up to a building. So there's nothing there. The right side setback doesn't matter because it's going internal to the campus. The left side setback is the one at issue. It's only 15 feet from the property line.
So wait, when you say left side, I'm sorry because I'm not good at directions, but I'm in Record Appendix Volume 2, page 76, looking at a lovely photograph of your client's house on the right, and then, or my right, this side, and then his driveway, and then some green space with some trees that look deciduous, but don't quote me on it, and then the existing building. So my understanding, and please correct me wherever I go wrong along the way, is that the new classroom structure was going to be built on that green space that is to my left, or the left, if you're standing in Queen Street, to the left of your client's driveway.
Correct.
But that it was going to go, and it was going to go toward the trees, but not necessarily require that the trees be cut down. Is that, some part of that wrong?
We don't know about the cutting down. I don't know how this can go in within 15 feet of the side setback and the trees be preserved. I know there has been discussions that that would happen. There's hope that that would happen, but I'm not certain that it can.
Okay, but the space that your client is angry about is this green space that I'm looking at that from Queen Street is to the left of the driveway, looks like grass and now has these trees in it. And also, I think there's space I can't see in this photograph, but the existing classroom building obviously doesn't come all the way to Queen Street. So there's also some green space between the front of the existing building and the sidewalk on Queen Street.
Correct. That's part of the treed area that you're looking at. That's correct, Your Honor.
Besides the actual picture of, you know, none of us are architects, thank heavens, right? My problem.
Well, for the clients, anyway. I think it'd be fun, but I don't think I'd do a good job.
As I say, thank heavens. So on this particular issue, from a legal point of view, here's my problem, and help me understand why it's not a problem for you. Your client's in a butter, rebuttable presumption of standing. School comes in and presents some evidence that you don't like, the shadow study and Spang's affidavit, that the judge says, okay. Goes back now to your client to say, show me some special and particularized harm, right, in a grievance. And when I look at Shepard and I look at Murchison, you didn't do anything other than just kind of generalize, say like, it's going to feel boxed in. Oh, what was already a crowded neighborhood is now going to be even more crowded. My problem with it is that, you know, like a tennis game, the ball came over your side of the court, and I don't see how, given what I read in Murchison and given what I read in Shepard, that you've established that you have some particularized grievance different that gives you standing. Tell me why that thought is wrong.
Well, it's more particularly the Shepard case, Your Honor. We pretty much follow the exact same scenario as is talked about in Shepard, where the appeals court there said that the last remaining avenue of open space or not being boxed in for the party was closed off by this zoning relief that was provided to a neighbor. The affidavit that I submitted, that's part of the record, and Mr. Watkins' testimony talk about the fact that in his backyard, he's got triple deckers abutting him.
Right, so he's fenced in. You're running out of time. I would just kind of want to fast forward you. He's fenced in on 3 sides, and this is his one, like, breathing space.
One remaining, yes, and that's precisely what the Shepard court took issue with. Beyond that, this is at the motion to dismiss level, and while I understand what you're saying, Your Honor, at the time, I challenged the fact that the plaintiff didn't provide, the defendant rather, did not provide evidence, because there's nothing there that shows that that they can prove that we don't have the ability to prove a particularized harm, because a brick building, a massive building, is going to go into what is the last remaining open space in that entire neighborhood, and it's just going to totally box in his property. And under the zoning code, the DND, this is not permitted. That's what's supposed to be addressed by the zoning board when they're granting relief, that type of situation. Now, I understand that it creates issues. I think the question about, does this mean they can't build there? It doesn't necessarily mean that, no. But this project is going to basically have him totally walled in, and it's the Shepherd case. Murchison's a little different for different reasons, Your Honor. There was no claim in Murchison that the neighborhood was already crowded like this neighborhood is. And I think if you look at, there's an aerial photo. I know it's on page 99. I forget which volume. If you look at that, that tells the story here. There's nowhere to go in Dorchester. That's why the DND was passed back in.
I think we understand your argument, and you've run out of time. So unless there are further questions, we're going to have to leave it there.
All right. Thank you.
Thank you very much.
Thank you.
Excellent argument. And we will hear now from Attorney Carter.
Good afternoon. May it please the court, Kate Carter for the defendant appellee, the Neighborhood House Charter Foundation. Your Honors, the Superior Court properly concluded that Mr. Watkins failed to put forward any credible evidence once the foundation had sufficiently rebutted his presumption as a direct abutter. That decision is well supported by the record appendix and is not clearly erroneous. I'd like to clarify the layout because it sounds as though there may be some confusion here in terms of what is being built. The project, the 2019 project that's being proposed and for which the foundation received zoning relief will build both a classroom extension, which is going to simply extend from an existing classroom wing that is set 35 feet off of the shared boundary line from Mr. Watkins' property. This is along his southern boundary line. So that is an existing 3-story, 42-foot classroom wing. It will be extended to make space for 12 additional classrooms and some auxiliary space.
Extended all the way to Queen Street.
It will be extended compliant with both a front yard setback and
but
yes,
essentially, as far as it can go.
Correct. Yes.
Toward Queen
But there
Street.
was some mistaken suggestion that it's only 15 feet from the property line. It's 35 feet, which is 3.5 times the side yard setback.
Okay, I'm sorry because I'm thick, but first of all, south, I'm from here, so south doesn't really help me at all. You mean toward the street? Toward Queen Street, is that south?
So
Never mind, it doesn't matter what's south. Is it just getting longer out from the building? It's not getting wider toward
Correct.
Mr. Watkins?
It is
Okay,
not moving
thank you.
towards, it is not moving, nothing is moving closer to Mr. Watkins.
Well, wait a second, though. It's not, how do I put this? It's not moving closer because it's still 35 feet, but it is, other parts of his house will now have school building closer to them because it will go all the way out to Queen Street. So, for example, his front porch is some diagonal distance now from the building that's longer than 32 feet, but it will be 32 feet once this is built.
So, Your Honor, the extension is moving parallel to Mr. Watkins'
Yes.
property. So you're right, there will be building where there was not previously building. Absolutely, Your Honor. It's not moving any closer to Mr. Watkins' property, and it's certainly not moving any taller. That wing is 42 feet already. It's three stories tall, and as Mr. Spang's affidavit attests, it will remain. And the reason why that's important, Your Honor, is decisions like Shepherd, Dwyer, some of the other decisions cited to in Mr. Watkins' brief, and the type of harm that Mr. Watkins has alleged, right? He said, I'm going to feel boxed in, I'm going to feel crowded. In fact, in his interrogatory answers, which are a part of the record appendix, he says, things are moving closer to me. Well, in Shepherd, for instance, that was a decision in which the project proponent actually was looking for a side yard setback. So whereas the setback in that case was 10 feet, the project proponent needed zoning relief in order to get closer to that. They were 6.5 feet on one side, 4.5 feet on the other. So in fact, again, it was encroaching onto into the plaintiff's space, into their property interests. And that nexus is really important. It's not enough simply to say, Your Honor, they needed to get FAR relief. Your Honor, they needed to get maximum story and maximum height relief. They have to show how that relief, the injury that the plaintiff has alleged, flows from the particular relief.
Okay, so all he talks about now is FAR, or at least all we talked about at oral argument, and maybe in one other variance that he's concerned about. But let's start with FAR. Without FAR relief, you couldn't build a building this big. Now, I have no idea what you could or couldn't do, right? But if the reason the FAR has increased is because of building straight up, and it's the gym and it's way over here, then maybe the FAR relief doesn't have anything to do with his property. On the other hand, if you were told, no, your FAR has to still be 0.67, maybe you wouldn't build out the classrooms this way. Maybe you'd build the 5-story gymnasium. You couldn't build all of it, right?
Your Honor, I can't answer that question specifically. I don't have the answer to that. I will say that I acknowledge that FAR was part of the complete package, right? We needed that FAR to build the project that we've proposed. And we certainly needed a maximum story, maximum height to build to the height that we were. But that's because of the dimensional regulations that are being relied on. But that still is not the cause of the harm. And let me give an explanation of how FAR doesn't necessarily affect the size of the building. The best example for that is actually the 81 Spooner case that's cited to in both of our briefs. In that case, the plaintiffs were on either side of a lot that had already had an improved home on it and that was being subdivided by an A&R plan, so that there would now be 2 homes on 2 lots. And the plaintiffs in that case were challenging density-related harms as a result of FAR. And they were saying that they were going to be boxed in, et cetera. Interestingly, the FAR violation in that case related to how the attic space was going to be used. But with changes to the interior of that building, removal of livable space in that attic, the FAR violation would go away. Now, that wouldn't change the size of the building, right?
Yeah, but that makes it sound like FAR relief can't ever harm a person, right? Because although you could still build the 5-story building, if you just got rid of the floor of the 5th floor and had incredibly high ceilings, you'd have less FAR. The building would be exactly the same size. Do you see what I mean?
I understand that, Your Honor, but what I'm saying is that the FAR for this project is not the cause of Mr. Watkins' claimed injuries of feeling crowded. It's
What is it properly under then? Because his feeling,
right,
whether you're of being boxed in, and now because all these other apartments in condos are touching. I only had this one space. So if it's not FAR, what is it?
Well, Your Honor, we think that the court, as the court identified, it's a combination of other things. It's lot size, it's lot width, it's setback, it's frontage, all of which our project complies with. This project is, this lot is 20 times larger than the minimum lot size. And that's relevant, Your Honor. Mr. Watkins in his brief says that's immaterial. Just because you comply with some of the density regulations doesn't mean that you get to violate others. But in fact, it relates to his standing. Those are important to consider because as the Mowry decision and the Dwyer decision, lot area and frontage are specifically the types of dimensional regulations that are intended to regulate a butter's sense of being boxed in. And in fact, there's a great example actually from the Dorchester zoning code that draws a direct connection to how setback actually regulates the massing of property. If you look at section 65-38, this is a section that talks about the design regulations that need to be considered when designing in the Dorchester district. It's at volume 2, page 101, Your Honors. And it says, oh, I'm sorry, I'm citing to the wrong one. Let me just get to my notes. This is, I'm sorry, section 65-37. It's at volume 2, page 102, and it says setbacks, again, talking about setbacks, corner treatments, and other design details should be used to minimize the sense of bulk structures. So, Your Honor, where we comply with lot area, setback, frontage, lot width, we have, through the Spang affidavit, demonstrated that compliance and therefore rebutted the presumption and shown that Mr. Watkins' evidence is non-credible. In response, then, he maintains the burden without the aid of presumption of coming forward with specific, non-speculative, credible evidence. And he only, in response to our 12B1 motion, submitted 2 affidavits. One was Mr. Timmons' affidavit, which attached some old maps. But again, the fact that the neighborhood is already overly dense is insufficient to demonstrate the type of injury that's required for standing as a result of a density-related injury.
So what do you think a density injury is?
I think, Your Honor, it's when you're coming too close, when you're crowding with setbacks, when you have the case.
Well, okay, so I get that if you got a variance from the setback and it was closer in that way, I guess that just brings me back to FAR and the kind of metaphysical question of how you're supposed to figure out what aspect of the building is caused by the further FAR relief. I mean, the answer is the whole building, every inch of it, in a way.
Yes, Your Honor. And I will just note that, again, there are 2 aspects of this project. There's the classroom wing and also the gymnasium. The classroom wing only accounts for 60%, obviously the majority, but only 60% of the additional square footage that's being added. But I just note that—
But it's all one project. The FAR is a calculation for both buildings together.
Yes,
okay.
Your Honor. Yes. But just to rebut, just to point out the insufficiency and the court's finding that Mr. Watkins' evidence, once his presumption had been rebutted, he submitted an affidavit that talks about his views, right, his views of the neighborhood and the loss of views of the majestic trees. As Mr. Timmons acknowledged, the foundation has not determined whether or not those trees need to be removed, but certainly those are along the property line, not impacted by the project or the footprint of the building. The views of the neighborhood will remain. Mr. Watkins testified in his affidavit that among the places where he tends to spend time on his property, it includes the front porch. That front porch looks directly across, continues to look up the street to Claymont Terrace and his neighbors, but also looks across at a second parcel owned by the foundation, which is a playground and park that will remain as is. And the best example of that, Your Honors, and I'm not sure that was emphasized, is in volume 2, page 70, where there's this green space, this park, that's directly across from Mr. Watkins' property on Queen Street. That remains unchanged.
So those majestic pines, those are on the school's property, right?
They are, Your
And
Honors.
separate and apart from all of what's going on here. Couldn't the school just decide to take a big old saw and cut the trees down and ruin his beautiful view of the trees? They're on the school's property, right? And say, like, it's too dangerous for the kids to be playing under this tree, or it's got bugs or whatever, right? I mean—
Is that right?
So I don't know if there's a specific tree ordinance in the city of Boston. I suspect there probably is. But the concept is correct, is that we didn't need zoning relief for this, right? And Mr. Watkins' injuries need to flow from the zoning relief that we obtained. But I think you're getting to another point, Your Honor, which is that the notion of view, right, that subjective view, Kenner has instructed us that unless the zoning ordinance specifically protects private views, which Article 65 does not, that view is not a legally cognizable interest. And I actually think that the Zhang decision that I cited to in my brief is a really interesting case where the plaintiff in that case also was talking about protecting his view of the surrounding neighborhood. And that's the type of de minimis interest, particularly in an urban setting, that cannot constitute the type of aggrievement sufficient to give one standing. I'll just very briefly, with my remaining time, address the shadowing concerns and the suggestion that the Spang affidavit was insufficient to rebut Mr. Watkins' presumption on shadows. Unlike in the Epstein case, where the shadow study was not accompanied by an affidavit that explained its contents, the Spang affidavit does exactly that. Lawrence Spang was the principal in charge at Arrow Street who oversaw the project since its inception. He talks about how there was three-dimensional modeling for the before conditions for shadows and the after once the project's built. He identifies the 3 times of year. He explains why the fall equinox and the spring equinox are the same in terms of shadows. He explains how the relocation of the gym to the south of the classroom wing will not impact the shadows on Mr. Watkins' building because that classroom wing is taller and to the north. So that is not the type of it is not on all fours with the shadow study that was challenged and ultimately thrown out in the Epstein case. And in response to that shadow study, Mr. Watkins did not come forward with his own expert testimony. He, as he acknowledged in his deposition testimony, which is a part of the record appendix, acknowledged that his belief that there will be shadows or impacts to air is based on his own opinion and speculation. If there are no further questions from the bench,
I see none. Thank you for an excellent argument.
Thank you.
The case is submitted. The final case we will be hearing this morning is also partially impounded. I trust that counsel is aware of the scope of the impoundment order. It is number 25323, Scott versus Hill, and we will hear first from Attorney Cherney.
Good afternoon, Your Honors. David Cherney, along with my associate, Alexis Delaquila, on behalf of the appellant, Venice Scott, in this matter. This is an appeal of a divorce judgment entered by the Norfolk Probate and Family Court. And there are 2 principal areas within the divorce judgment that we are challenging. First are the custodial decisions made by Judge Gorman to Ariella, a 5-year-old daughter of the parties. The other is the equitable division, and I'll quote equitable division, issued by the judge in this case. To start off with the custodial aspects of this case, what the court needs to look at first and foremost in making an assessment of custodial arrangements is what is in a child's best interest. That's first and foremost. And in this particular case, as I indicated, the child was approximately 5 years old. It was a 4.5-year marriage of the parties from the date they got married up until the original divorce action was filed by the father in this case. At that point in time, in September of 2020, the youngest daughter, who had been born the previous December, was approximately 9 months old. So for the bulk...
There's only one child, right?
One child,
You said the
yes.
youngest daughter, okay.
One child. During the bulk of this child's life, she's been involved and embroiled in the midst of this litigation between the parties in this case. In looking at it, the real issue of review by this court is the standard of, did what Judge Gorman do in this case, was it clearly erroneous? Was there any evidence that wasn't considered, or was a mistake made? On the custodial issues, if we can demonstrate an abuse of discretion in the judge's accounting for the best interests of the child, the case needs to be reversed. We say there are 3 areas that the court should first look at. The first is the issue of what is truly in the child's best interest in this case.
That's a discretionary call, though, isn't it, for the judge?
It is a discretionary call, and
Would have to find an abuse of discretion. which is a pretty high bar.
I agree with that, Judge, as is the determination of credibility by the judge in this case after.
We can't even undo the determinated right. I don't think we even have authority to do that. I mean, maybe it's clear error of some kind.
The judge made the findings she did. They're set forth to the extent that they are findings in the case. But the other issue that really needs to be looked at in this particular case is in looking at all of the evidence that was introduced, and there was really only testimony of the two parties in this case, plus a plethora of actual physical exhibits in this case. But is the finding that the judge made, and there's one finding I'll submit that the judge made, she says, I think it's in this child's best interest that the parties share equal physical and legal custody. And what the judge didn't look at in this particular case that we say is error is, number one, she didn't look at the history of what had been going on with this child since the divorce action was filed.
Well, I just want to pause you on that. You say she didn't look at the history, but the temporary, was there a different judge managing the case during the time that the temporary orders were entered?
There were 5 separate temporary orders entered in the case during the time from when it was filed up until the divorce came
And
out.
were they entered by judges other than Judge Gorman?
I believe they were all entered by Judge Gorman, but
Okay.
they're set forth in the findings. But I don't think it really makes a difference if it was a prior judge or...
No, I'm not suggesting that maybe that there was some shuffle between the judges. You say she didn't consider them, but she was there for them. So I guess that's what I'm just trying to make sure I understood correctly, is that presumably as she looks at the case, she thinks, oh, right, this is the case in which I already entered these 5 temporary orders.
I think it's unique to see a case like this in today's day and age where there is an award of not only sole legal custody of the mother, and that's a big difference between joint legal custody and sole legal, but in this particular case, under the 5 temporary orders that were entered, she had sole legal custody of this young child, number one.
But surely that doesn't mean that that can't be changed in the final order.
That's true.
Temporary orders are temporary.
Well, we always say temporary orders tend to create a presumption of some level of permanency, but it is a temporary order and it can be changed. I agree with that, Judge. But in this particular case, on 5 separate occasions, you had findings and orders of sole legal custody and primary physical custody to the mother.
Now, of course, there was a restraining order for some of this time, I'm guessing.
I think pretty much for all of the time, the restraining order
And the
entered
judge
into.
makes some findings about that at the end of in what's under review with us, some findings about the restraining order and also about this violence between the parties.
Correct, and I think that's an important consideration. That's one of the considerations when I talk a little bit in the brief about the findings and the consideration of domestic violence in a case and how that is.
No, but I'm just saying I can imagine a judge not having sorted through the details, creating temporary orders like that, then sorting through the details and finding what I gather the judge found, which was less there than meets the eye.
Well, I think when you look at this, the trial was held on 3 separate days, February 2nd, May 20th, and June 21st, I believe, of 2024. And then after the case ended in June, it wasn't until December 27th of that year, 2020, that the judgment came out. And I think, in looking at this, the judgment entered here was more a function of a result-driven judgment than one that was truly based on the evidence presented at trial. Judge Gorman, I believe it was her last or her next to last judgment that she actually entered in the case on Friday, December 27. Judgment came out the following Monday and Tuesday with the new year, and she ceased being on the bench. She had retired at that point in time. And I think that there was a real rush to get it out and rush to reach an accommodation that, number one, somehow considered, and we say not enough considered, but considered that there should be a disproportionate division of assets. And on the issue... Wait,
I thought we were talking about custody. Are you moving into the assets question? No. Okay.
No, but I think that those were the 2 issues that were result-driven by the judge.
So as I read, and tell me if I'm looking at the wrong thing or if I should be looking at an additional thing, as I read the Memorandum in Support of Judgment of Divorce, which is that December 27th, 2024 document, with respect to the domestic violence. Is there still a 209A order, by the way?
There is.
Still existing to this day?
Still existing today, yeah.
Okay.
It's been extended.
So as I read page 8 of the judge's order, which is at volume 4, page 290 of our record appendix, the judge found, in somewhat equivocal language, this is 289 to 290, mother gave one example of father reportedly grabbing her by the mouth and neck when they were arguing. As a result of father grabbing mother, mother fell on the couch and a physical altercation ensued between the two of them, with each of them biting the other on the hand. So do you see that as a finding?
I do, Judge.
And having said that you see that as a finding, do you believe that that is a finding under Section 31A of a serious incident of abuse?
I do.
Okay. So then I take it your position, which I think was expressed in your brief, though I got a little confused about the interplay here with Section 31A and Vaughn, but I think your position is that the judge committed an error of law when she assigned joint physical and legal custody without specifically making findings about why that was okay in light of this serious incident of abuse.
That's exactly right, Judge. And I think both under Vaughn and under 31A, if there has been a finding of serious abuse or a finding of abuse or a pattern of abuse or whatever it is, and the statute really doesn't talk about, and the cases don't talk about how much abuse do you need to show before it rises to that level. My opinion is that one is more than anybody should be subjected to. But upon that finding, in order to then take the leap, especially in a case where for 5 years the sole temporary orders had been sole legal and primary physical to mom, you really need to make the specific findings that Vaughn talks about of how that may or may not impact the best interest of the child in this case, and that was not done.
So where this case, so there's also the mother sought a modification somewhat recently, like, I don't know, late this year is that right?
That's correct.
So there is a probate and family court judge who is currently assigned to this case, even though it's not Judge Gorman, is that correct?
That's correct. Norfolk has gone through a series of changes and cases have moved from judge to judge, but this case is now under the docketing system assigned to a specific judge and being heard by that judge. And we had filed a motion in the appeals court for leave to file the modification, which I think we're required to do, and that was allowed by this case. So that case is still pending and going on at this point.
It is. Do you know the next date on that case?
I really don't know the next date.
Sorry for the pop quiz.
I know that it's relatively recent and active case that's going on. It could very well be that is brought forward and there's a decision in that case before you folks even issue a decision on this appeal. But that's why we have the procedures that we do and we filed for that. But I think to go back to it, the lack of findings made by the judge here under Vaughn or under 31A, whatever you want to look at it, as to how this incident of physical abuse.
Okay, the issue I have with this is that if it's an incident, not a pattern, and I think the judge didn't find a pattern, if it's an incident of serious incident of abuse, then it has to put someone, it either has to be an attempt, either cause or attempt to cause serious bodily injury or put someone in imminent fear of serious bodily injury. But then it says the definition of serious bodily injury is from Section 13K of GLC 265, and that reads, serious bodily injury, injury which results in a permanent disfigurement, protracted loss or impairment of a bodily function, limb, or organ, or substantial risk of death. Which of these was the fight described there? It doesn't seem like it rises to that level. I mean, it's deplorable, but I don't know that it rises to that statutory level.
The testimony of the wife in this case is contained in Record Appendix Volume 1 at page 67 of this incident, where she says that he grabbed me by my mouth, then to my neck. I fell back on the couch. He came over to me. We started fighting. I bit him on his finger. He bites me back. Ariel was there, and that's another issue. The child was there, even though she was of
I didn't ask you that. I asked you about serious bodily injury, because in order for the statute to apply, or at least, you know, the 31A presumption to apply.
Well, 31A says, for the purposes of this section, abuse shall mean the occurrence of one or more of the following acts between a parent and the other person, or between a parent and a child. A, attempting to cause or causing bodily injury. Uncontradicted testimony that that happened here. B.
Yes, but unless there's a pattern,
well, it doesn't.
Then okay, I mean, I'm just reading the statute. You can quarrel with me about what it says, but it says serious incident of abuse, because not a pattern. Serious incident of abuse shall mean the occurrence of one or more of the following acts: attempting to cause or causing serious bodily injury, placing another in fear of imminent serious bodily injury, and then it says serious bodily injury shall have the same meaning as provided in Section 13K of Chapter 265.
I think, Judge, if
Can
you...
I just jump in for a moment? There seems to be two arguments, right? One is that written findings are necessary when there's evidence of domestic violence. And you say, to explain why the best interest of the child supports this joint custody, you say the judge didn't say enough, didn't acknowledge enough.
That's
correct. The second is in instances, as Justice Rubin has pointed out, whether there's a pattern or serious bodily injury. Then,
I think
then there's a rebuttable presumption. Okay, and so are you suggesting that there's a rebuttable presumption that the quote-unquote abusive parent should not have been given shared legal and physical custody?
Yes, I do, and I think the findings need to be made to demonstrate why that was ordered. I've set forth the other arguments, my brief on the custodial issues. I see my time is drawing near. If I can just briefly address the issue of the division of assets in this case, keeping in mind this is a 4.5-year marriage, and I think the uncontradicted testimony that you have before you in the trial transcript shows that approximately 14 years before she married her husband, she had owned this particular one house, and then later on after the marriage, shortly after the marriage, about 8 months afterwards, she financed that house to buy a second rental property, and the evidence is pretty clear that that second rental property on Rosewood Circle was one that was acquired by a refinancing of the original piece of property, as well as money that was given by my client's grandmother in this case. There was testimony by the husband of things he did. It was contradicted by, I think, his own testimony at times. But the reality is, with a 4.5-year marriage and looking at what each contributed to acquire capital assets and income, the judge's sort of catch-all cover that somehow dividing assets 60-40, including the retirement accounts, covered that, I'd say, is erroneous in this case.
Your time has expired. You should know, of course, we're familiar with these arguments from your
Thank
brief.
you, Your Honors. Thank you.
And they'll be given full consideration. Thank you. Very good argument. We will hear next from Attorney Spencer.
Good morning. Members of the panel, good afternoon. It's been a longer day than that. May it please the court, I'm Sean Spencer for the appellee Don Hugh Hill. I recognize it's been a long morning. I'll confine my arguments to what I think you need to hear at this point, and I'm happy to answer any questions you've got. So Judge Gorman listened to these parties testify for 3 days. She watched their demeanor. She decided whom to believe, whom not to believe, and she made a number of very specific findings on which she did not find the mother's testimony credible. There was voluminous evidence on which she could have based both her custody determination and her division of assets. And I'd suggest that under the court's standards of review, the decision below should not be disturbed.
I agree with you that the judge made a number of credibility findings related to the parties' representations of their roles in cultivating their real estate holdings and paying for them and working on them. The place that I think she didn't make a finding, and the thing that worries me about that is, as I read that section I read about the choking and biting incident, it sounds like the judge was skeptical about the mother's representation, but the judge doesn't find that the mother was not credible. And there's a 209A order that is still in effect. And now we've lost the judge who saw and heard these parties over the course of 3 days. And so I'm just, what's your position about why 31A and Vaughn do not require a specific articulation of why it's appropriate for the child to be in shared custody?
Sure. My first point, and it's a brief one, is that Vaughn is not a 208 case. We're here under 208, not 209C. Now, it's true that the legislature read Vaughn and 2 years later said, great, let's amend both statutes, 208 and 209C, and insert those findings that Vaughn required in new sections. So that's how we get to 208, Section 31A. 31A, the provisions on which the mother relies, first of all, it requires that the judge have issued a finding by a preponderance of the evidence that there was a pattern or serious incident of abuse. Here, below, on page 292 of Volume 4, the judge finds that the husband did not commit cruel and abusive acts in dismissing the counterclaim, or the wife's first complaint for divorce. So the statute is not triggered at all because there's not been the required finding. Second, on the evidence that came in, there's simply no doubt that, and I want to be clear here, the laying of hands on one another is unacceptable. So I'm in the position of arguing that it doesn't meet the statutory definition, which it doesn't. I don't want to appear to minimize the conduct. Chapter 265, Section 13K is very explicit. The conduct alleged here doesn't rise to any of the factors, any of the elements described there. And even here after argument, we've not heard what section plausibly could apply.
What about the statement in the affidavit in which the wife indicates that there was a history of abuse?
Well,
so when we talk about pattern.
Right. If it were enough for a party to just say abuse and the judge just has to accept that and say now this statute is triggered, I don't see how that wouldn't happen in every case where someone wants to push and gain an advantage for custody. Here what we had is the mother's live testimony before Judge Gorman. She heard it at length. And I think if you read not just the portion of the findings that was read before, but also what came right after it, she characterizes the attempt to obtain a 209A order based on not giving a computer cord to the mother.
No, I don't think that's right. I think she says there was this complaint about the cord, but that the 209A order was based on just a statement, I am in imminent fear of physical harm.
Your Honor, and you're right, I apologize. It's the calling of the police. Calling of the police is what I said.
But that's...
I retract that.
That's
my error. Called the police because of the computer cord, and then, despite the divorce action being pending, a month after filing it, went to a different court to seek the 209A order, and that's why I referenced 209A. I think all of that makes clear that the trial judge just was not believing the mother's position below.
But she didn't say that.
Well, you're right, and she didn't have to say that. That the evidence was not there to require her. It's not clearly erroneous for her to have found that the husband did not commit cruel and abusive acts.
So, but help me understand this. If what I think the judge accepts, that there was a physical altercation in which husband put hands on wife, right? And she fell, then doesn't there need to be some written findings of why still, when there's evidence of domestic violence, not rebuttable presumption because it doesn't fall within the 265-13K, but doesn't there need to be more of why it's still in the best interest of the child to have joint custody, even though this one incident happened?
That would only be the case if the first paragraph of Section 31A were triggered. That requires not the pattern or serious incident, but abuse, again, as defined under Chapter 260.
Well, it seems like it's within the definition of abuse. Any
Your Honor,
fight, right?
I have to disagree on that one, because the
It
legislature...
may not be an incident of a serious incident of abuse.
So the statutory terms are that there must be a serious impairment of the physical condition. This is abuse, not serious incident of abuse. And that means, or including but not limited to, a burn, a bone fracture, a subdural hematoma, an injury to an internal organ, or repeated harm to a bodily function or organ, including the skin. That is...
Sorry, 31A defines abuse, and it's just like a restraining order. Serious incident of abuse is something different, and serious incident abuse is when then the rebuttable presumption occurs for the abusive parent. So even with no pattern and no serious abuse, my question being is, if there's evidence of domestic violence, doesn't the judge still have to specifically write a finding of fact that details why still joint legal and physical custody is appropriate?
I would say no under 31A. And here's how, to take the high level of how it should work. If there has been the finding of a pattern or serious incident, that's when 31A, paragraph 2 and 4 would require the findings and the rebuttable presumption. If there's only been abuse, which is defined by paragraph 1 of 31A to mean bodily injury, not serious bodily injury,
Then what?
then you can take that as a factor contrary to the best interest of the child. It doesn't in fact require specific findings, but presumably that's what the judge will do.
Can I ask you a question? I thought, maybe I'm confused here. I thought Justice Walsh asked you if the mother had not said that there was a history of domestic violence. But then here in the order that's under review, it says, mother credibly testified that there were no other acts of physical violence between the parties during their marriage. Is that what, when we look at the transcript, are we going to see her credibly testify or testifying to that?
I'm not just conceding that she credibly testified. That is, in fact, what the judge found.
But I'm asking about is that a supported finding? Is that what mother's testimony was at trial?
At trial, yes. The only evidence, and this is what Justice Walsh pointed to, was the affidavit that was introduced into evidence along with the 209A order.
But to be fair, that question, that response was triggered because the question was, since that incident with the couch, has there been anything else? And the answer was no. And so that finding is directly related to that. And there was no testimony, even attempted testimony, about the prior incidents during the course of the marriage of physical abuse.
And there was no testimony in the record at all about any prior incidents, so I don't want to accept that there were any.
Well, I mean, I'm looking at volume 1 of the record appendix on page 64, and part of my challenge in unpacking this testimony, maybe you can help me in this, is it's not clear to me when this choking, biting incident happened. Is it clear in the record when that happened? I know she went in early October to get the restraining order. Did this incident occur in October? Do we know?
My reading of those 8 pages, and it's difficult, the testimony is halting. My reading is June 2020.
Okay, so June was the cord incident. Do we think June was also the choking and biting incident?
Yes.
So the mother tries on a number of occasions between pages 64 and 67 of volume 1 of the record appendix to talk about prior physical altercations. And every time she says that, there is an objection that is sustained. So it is true that there is no testimony in the record about other physical abuse, but it's not true that there was no attempt to bring in testimony. So I do think where the judge limited what came into the record, it's a little disingenuous for us to say, well, there was nothing else in the record.
Except, and this is awfully important, To say there might have been other testimony of abuse presumes that this is testimony of abuse, these 9 pages of transcript. And I'd submit that is not what it is. It is testimony of laying hands on one another that is unacceptable. But abuse means bodily injury as defined under 265, Section 13K.
No, serious bodily. Abuse means abuse under 209A, serious bodily injury. And the definition of abuse of that, which creates a rebuttable presumption, is something more serious. And I mean, I'm just looking at, she attempts to testify about prior altercations. Objection, motion to strike the prior altercations. Stricken about the prior altercations. How can she even introduce if there were 20 times, and I'm not, you know, hypothetically, that there was abuse that doesn't rise to the level of serious, but is certainly a pattern. We don't have the record for that because, as Justice Hershfang said, it really wasn't allowed to be developed.
Your Honor, let me address that after I make this point, which I don't want the court to lose. Under the first paragraph of 31A, abuse, not serious or pattern, abuse is defined to mean bodily injury under 13K, not serious.
Yeah, but grabbing someone by the mouth or biting their finger or whatever probably counts as, I mean, I haven't looked all the way through it, but those are probably bodily injury.
Well, it includes, so bodily injury includes subdural hematoma, which I'm pretty sure is just a fancy bruise, right?
Your Honor, I don't mean fluid building up between the brain and the dura.
Oh, that sounds terrible.
It sounds very bad. So if you look at all of the things the legislature enumerated in 265-13K, this is not that. This is also not okay, but this is not that.
I mean, I don't know how you read this 31A, second sentence. For the purpose of this section, abuse shall mean the occurrence of one or more of the following acts between a parent and the other parent or the child, attempting to cause or causing bodily injury, or placing another in reasonable fear of imminent bodily harm, right?
Yes.
So, and then the definition of serious incident of abuse is different, which creates a rebuttable presumption. I think the harder argument is if there's something less than serious incident of bodily harm that rises to the level of either a pattern or does it need to be factored in here and need to have written findings.
And the legislature, I'd suggest, has decided that. If there were evidence of abuse, meaning bodily injury, as defined in the last sentence of that paragraph under 265-13K.
Or a pattern, right?
Pardon me?
Or a pattern.
But I'm talking about a lower level. So there's a pattern or serious incident is one level, and the first section of 31A talks about merely being evidence of abuse.
Right, so if she was not allowed to testify about a pattern of behavior.
Well, I don't understand. What was the basis of the objection to her saying prior altercations?
I would imagine that it was, there was references to timeline, we don't know when we're talking about, or maybe assumes facts not in evidence. That is, tell me about the prior altercation when there's been no evidence of one.
Well, but she was about to give evidence of it. I mean, I don't understand. I understand why, for propensity reasons or whatever, you might let in a past bad act, but in a divorce trial, I would think you could talk about anything that happened during the marriage.
Well, let me suggest two things. Number one, there was no attempt to, well, I'll just say this. Counsel had time to attempt to lay a foundation that was satisfactory to the judge and introduce the evidence, and counsel did not.
That his wife's counsel did not ask about, did wife's counsel ask about the June 2020 fight? How did that come in? But didn't ask about anything prior or subsequent during.
Correct. And I mean, I wasn't trial counsel, but it would be easy, I suggest, to say, was there ever...
Yes, of course, I mean, I would think, but...
Yes. My time's expiring. I just want to urge you, on division of property, I cannot imagine a way in which the judge saying 60-40 favoring the mother, given her finding that the father's contributions were instrumental to increasing the estate by $1 million to $1.5 million in value, is an abuse of discretion. If it were, I'd be here on cross appeal saying 50-50 is the right amount.
Okay.
But that's discretion.
We, as with your brother, we do have your argument about the property as well, and I think we understand it. Thank you for a very good argument. Thank you both for excellent arguments.
Thank you, Your Honors.
And the case is submitted. That brings us to the end of our sitting. I'd like to thank the court officer and the court staff for their very helpful assistance today, and we stand in recess.